Good morning, everybody. Happy Super Friday. Welcome to the Courtroom Files Live. Let's get things rolling with Wade Mercer down in Florida.
I think an old check case that was dismissed, and that's it. Is that the only criminal history you have, ma'am? Okay.
Yeah,
that's great. Ms. Barfield, I need to figure out some living situation so we can figure out how to get you out of jail. Ma'am, your Miss Benefield is your daughter, correct?
Yeah, she moved out yesterday.
She wasn't living there, but yeah,
that was my question. So was she living there or was she not living there before the event?
She hasn't been there. She hasn't been there in 3 months. She hasn't paid me rent or nothing, and that's what we got an argument about.
Okay, so when you say she moved out, that was as a result of this incident or before this incident? You're pretty confident she's gone.
So she's gone. Yeah, she destroyed the house. Yeah.
Okay, let's see if the attorneys have any additional information before I address your bond or release status, Ms. Barfield. Mr. McDaniel, anything?
No, we just asked for maybe some kind of cash monetary bond or something. I mean, she's local and don't have really no criminal history. And I mean, obviously the complaint itself is not questionable, but it's, it is what it is. We just asked for some kind of cash bond.
Thank you, Mr. Mitchell.
If she wants to post a cash bond, the state has no objection.
So Ms. Barfield, given your history and Mr. McDaniel, what I read the complaint, I see exactly the point you're making. It does not appear to be it's like one of those cases the officer possibly could have arrested either or both people based on what the complaint says, ma'am. So what I'm going to do is I'm going to let you pick between a conditional release and a bond, a cash bond of $250. It's entirely your choice. You will have a condition of no contact with the alleged victim either way. So you can have no contact with her. At least if you both want contact, we'll cross that bridge in the future. But right now, no contact. And the cash bond or the conditional releases, either one is fine. Do you have any questions about that choice, or do you know which one you want to choose?
I'm gonna do the cash bond, please.
Okay. So your bond is $250 cash. Standard conditions of every cash bond. Those standard conditions are no new law violations, don't miss any court dates, no contact with the alleged victim. Ms. Barfield, also want to ask the jail to give you a notice for your arraignment date. That will be January the 5th at 9 a.m. So they'll give you that written notice, ma'am, before you leave the jail, January 5th at 9 a.m. You will not get a notice in the mail. So, ma'am, make sure you hang on to that notice and be in court that day. So let me talk to your fiance. So she's chosen a $250 cash bond. That $250 has to be posted at the jail. When that's posted, she'll be released. And then they'll give her a notice for her court date. Do you have any questions, sir? Ms. Barfield, do you have any questions?
No.
All right, man. Wish you the best. Hey, Ms. Barfield, one more thing. You may want to call the clerk's office like a couple days before your court date. There's a chance Mr. Mitchell will look at the case and decide not to go forward with it. That's possible. It's also possible he'll look at it and decide to go forward with it. So I'd call the clerk's office before my court date, so you wouldn't, if he's dismissed it, I don't want you coming up here and wasting your time. But
Right, I
Mr.
understand,
Mitchell will
I
take a look
understand.
at the case, okay?
Yeah,
Jake,
All right.
if you let me know like you normally do, I'll let her know.
Yeah.
Thank you. So, sir, as soon as that 250 is posted at the jail, she'll be released. Sir?
How would I know when it's been posted?
Well, I was assuming you're gonna be the one to post it. Okay, so if it's posted, whoever posts it will have to post it at the jail. So I'm assuming she would call you or they would call you, but as soon as it's posted by someone, she'll be released. Okay,
Wait for the jail to call me?
or her, or family. I don't know who's gonna post the bond.
I don't know either, 'cause I mean, I don't mind paying it, I just don't know how to do it.
Oh, if you want to post it, you take $250 to the jail.
Oh, okay.
If you want to post it, you take the 250, and she's probably wanting to know the answer to this. Do you have the ability to post a $250 cash?
I don't have a card.
Okay, you've got to take cash for a cash bond. So it can't be they don't take credit cards on a cash bond. So I want to make sure I don't want her to choose this thinking she's gonna get out and then have to spend the whole weekend in jail. So you don't have the ability to post a $250 cash bond.
I mean, I don't have cash on me, but I do have money.
But do you have access to the cash, like on a debit card? Okay, so you can go to the bank, get $250 cash, go to the jail, and she'll be released. Okay, so your fiance says he's gonna take care of that, okay?
thank you so much.
Yes, ma'am, thank you. Thanks, sir, for coming.
The jail does have an ATM also, don't they?
They do have an ATM. I don't know what kind of card it takes, or what the fee is or anything. I don't know.
Not sure if they didn't get rid of that ATM. Do y'all still have that ATM? No, they got rid of that ATM. It was more
Yeah,
problem than it was worth.
You're better off going to your own bank or wherever, to use that. Okay. Robert Hall. Mr. Hall, good morning. Mr. Hall, you're here because you've been accused of one count of failure to redeliver hired or leased property. Mr. Hall, there is probable cause for the charge. Mr. Hall, your criminal history is very, very lengthy. You've probably got 20 prior felony convictions, but they all were, it looked like it may have been the same point of time several years ago. You got a bunch of felonies there in one time period, so I'm aware of that. But let me see if the attorneys have any additional information before I address your bond status. Mr. McDaniel, anything?
Your Honor, we're just going to ask for a reasonable bond, and I don't know if there was restitution owed, but we have no objection to a cash bond if Your Honor wants to do that.
That's what I was thinking. Mr. Mitchell, any objection or any input on that?
You request a cash bond?
He's requesting cash bond, yes.
No objection to that.
Mr. Hall, I'm gonna set you a cash bond of $500, cash based upon there allegedly is restitution owed, Mr. Hall. So that $500 cash is posted, you'll be released. You do have a condition of no contact with that rental company. Let's see who it was. Was it Enterprise or was it a different one? It almost had to be Enterprise in Jackson County because we don't have any other rental companies, do we? 25329 CF. Let's see what company that was.
I don't know. I did rent from the Nissan.
Oh, there are
place.
some
Yeah.
dealerships that have
Yeah.
rental.
It was Enterprise, so.
So no contact with any enterprise that's accused you of this. But Mr. Hall, the other thing we're going to do is I'm going to ask the jail to give you a notice for your court date. So if you do post the cash bond, or actually they'll probably give it to you after first appearance today. Either way, your court date will be January 6th at 8:30 a.m. And they'll give you that notice before you leave the jail. Any questions, sir?
No.
All right, sir. I wish you the best. After Mr. Hall, we have Adelia Lopez.
Your Honor, the next two do not speak English. The next two persons on your docket there do not speak English. So, I can talk to them, but it's.
So Corporal, we didn't get an interpreter request this morning.
Yes, sir, that was a miscommunication between night shift and classification. And we thought they spoke English and apparently they don't.
Okay. Let me see Miss Lopez and see if she speaks any English, because I really don't want her sitting there another day if she's going to get a bond today.
Yeah, I don't have any objections to court. I mean,
Miss Lopez, do you speak English, ma'am? Chiquita. Habla un poco de español. Habla un poco de español, pero por favor habla despacio para que yo pueda entender. ¿Entiende? So what I said was, I speak a little English, but please speak slowly so that I can understand. Okay. That's basically all the Spanish I know, what I just said. So my question is,
Do you want me to go get Mr. Gill?
if Mr. Gill's available, I'd feel much more comfortable with that. Un momento, por favor. Te traemos un intérprete aquí en un momento, okay?
Okay.
What I said was, we're going to have an interpreter here in a minute, hopefully.
I did ask Gary if Deputy Bellini was here, but because he speaks fluent Spanish, but I think he's out, is what you said.
He now dropping his vehicle off at the office. He should be back anytime now.
Yeah.
So he'd be fluent.
What about the other Miss Lopez, Odalis Lopez? Is she there? Can I get her to come up, Mr. McDaniel?
Yes, Your Honor. I mean, I've got a translator here. I can, speak clearly enough, it'll translate it out for him.
Who is that?
I've got a translator on my phone. I mean, if you want to speak
Okay.
clearly.
Yeah, let me just wait just a second and see if Mr. Gill's available. Senora Odalis Lopez, habla inglés?
No, señor.
Un momento, por favor.
Your Honor, we could take the other two while we're waiting and see what happens with Mr. Gill.
We could, but we may walk in any moment. So let me just give it a moment first, please.
Listen here, Tim.
Where's Stacy when you need him?
I know. Fluent speaker.
I'm sure he's out doing that environmental study right now, so, I mean, but he'll probably call him and he'd help us.
Is that door locked? So it's probably Lawrence trying to come in.
Yeah, I need you, man.
Mr. Gill, I just don't want them to have to spend another night in jail to get a bond set.
Okay.
So we have Senora Adelia Lopez and Senora Odalis Lopez. If you would please let's start with Adelia Lopez. Ms. Adelia Lopez, you're charged with 1 count of battery.
Señora López, tienes una cargo de en contra de ti de pelear. ¿Me entiendes?
Sí.
Es un cargo es un delito menor de primer grado. It's a first degree misdemeanor.
I'm going to set you a cash bond of $250.
Tienes una fianza
$250.
$200-500.
If you post
Okay.
that, you'll be released.
Si puedes pagar, puedes salir del cárcel.
Your court date will be January the 5th.
Tienes una otra cita, una audiencia el 6 de enero
At 8:30 a.m.
a las 8:30.
Okay.
Do you have any
okay.
questions?
¿Tienes algunas preguntas?
Sí.
Not Thelma.
Pago, ¿cuándo puedo pagar
You're right.
y cuándo podemos salir?
She says, when can I pay and then when can we leave?
You will get to use the phone in just a moment.
Puedes usar el teléfono en algunos minutos.
And
Okay.
you can make that purge. You can pay the bond at any time afternoon today.
Tú puedes pagar en esta tarde. And she can pay whenever,
Anytime afternoon.
en cualquier momento.
The United
Okay.
States Immigration Service has until noon to place a detainer on you if they wish.
Inmigración, puedes
Mr. McDaniel has something that may change that. Mr. McDaniel?
Judge, they have social security numbers in Texas driver's license. I don't know.
The
You know,
sheriff's
that's-
department advised that the immigration service wanted them, so they're gonna have until noon to place a detainer on them.
inmigración, tienes hasta el 12 de esta día, so 12, right? El 12 para poner una orden de detener y we don't know if that's going to be happen, right?
3 hours and 15 minutes from now.
Ellos tienen 3 horas para poner una orden de detener, pero nosotros no sabemos si esa va a pasar. ¿Entiendes?
Okay. Sí, comprendo. Muchas gracias.
Algunas preguntas.
Yo
Any
no.
questions? Okay, so Corporal, if they're still here Monday, either one of
Yes,
these
ma'am.
ladies, put them back on the first appearance list, and someone at the jail needs to do the interpreter request
Yes, sir.
Okay.
I'll take care
if
of it.
they're still there, because we need to make sure they fully understand. So next we have Odalis Lopez. Miss Odalis Lopez, you're charged with one count of false imprisonment and one count of battery by strangulation. Those are probably difficult to translate.
I can maybe get those. Señora López, tienes dos cargos. El primer
Yeah.
cargo es false imprisonment. No sé cómo decir en español, pero es una cargo, un delito mayor del tercer grado. I told her it's a charge of a third degree felony. Y tienes otro cargo de pelear también. En eso es un cargo mayor del tercer grado.
Your bond is going to be $250 on each count.
Tiene una fianza de $200, $500 en cada cargo.
So your total
Okay.
bond is $500 cash,
En total es $500 en efectivo.
and you will get to use the phone in a few minutes to try to post the bond.
También tú puedes usar el teléfono en algunos minutos.
You will be given your
Okay.
notice for your court date, which will be January 6th.
También va a presentar una noticia para tu audiencia o tu cita de fecha de corte,
At
que es
8:30.
a las 8:30.
Do you have any questions?
What day was it? On
8:30, January 6th.
enero, el 8th of January.
Oh, 6th.
El 6 de enero también.
Do you have any questions?
¿Tienes algunas preguntas?
¿Dónde será mi corte?
¿Cómo?
¿A dónde va a ser mi corte? ¿Acá o
Where
en
is your
Texas?
court going to be?
The Jackson County Courthouse here in Marianna, Florida.
El courthouse here in condado de Jackson.
You both have a condition of no contact with the alleged victim.
Tienes una previso que no puedes tener contacto con el víctima o víctima.
Ok.
Okay, so can you tell them if you're still here on Monday, you'll come back to court with a court-approved interpreter?
Okay. Si no puedes salir del cárcel, si no puedes pagar el fianza, vas a devolver el lunes.
No
But you can
entiendo.
post the,
¿No entiendes?
she doesn't understand that.
Si no,
¿Qué-
ok,
qué no-
si no puedo pagar hoy fianza, puedo pagar hasta el lunes.
Tú puedes pagar en en cualquier momento. Pero si no
Ok.
pagas, tú vas a devolver el lunes.
Tú vas a regresar aquí.
Ok, ya entendí.
Ok. Gracias.
And your bond can be posted as of 12 o'clock today, which is a little over 3 hours from now.
Puedes pagar el fianza hasta después del 12 esta día. ¿Me entiendes?
Hasta,
No puedes pagar
Hasta-
la fianza hasta a las 12, 3 horas. No puedes pagar
Ah.
hasta 3 horas.
ok.
Okay,
Ah,
buena suerte.
solo cash?
Cash.
Ok, thank you.
Cash, efectivo, sí.
Ujú, ok.
Mr. Gill, thank you. I know that's not your job, but I appreciate you in a
It's
pinch
broken.
helping us out.
I think they got it. I think.
I think they did too.
Okay.
I understood every third or fourth word. So
Probably really broke it, but I think they got it.
thank you for coming over and helping us with that. I just didn't want them to have to sit there
Thanks,
another day just because someone at the jail forgot to do an interpret request. Thank you. All right, so after the Lopez ladies, the next case is going to be Kinshare Grants. Mr. Grant, good morning. Mr. Grant, you're here because you've been accused of 1, 2, 3, 4, 5 charges. It looks like 1 felony and the rest are misdemeanors, Mr. Grant. There is probable cause for these 5 charges. They are battery, misdemeanor criminal mischief, child abuse, that's the one that's a felony, petty theft between $100 and $750, and trespass. So, Mr. Grant, I'm going to set you a bond, but let me first see if the attorneys have any additional information they want to make sure I'm aware of before I set that bond. Mr. McDaniel, anything on behalf of Mr. Grant I need to be aware of?
John, I think
I
you're
think you're
muted.
muted. I can't hear anything. Either you're muted or you're not saying anything.
No, Your Honor, we don't have any.
Thank you. Mr. Mitchell, anything?
Nothing at this time, Your Honor.
So, Mr. Grant, I'm going to set you the normal bond I would set for these charges. For someone with prior criminal history, sir, that is going to be $2,500 on the misdemeanors each. There are 1, 2, 3, 4 of those. $5,000 on the one felony charge because it's a third-degree felony. Your total bond then becomes 12,000, 15,000. So it'd be 25 times 4 is 10 plus 5, $15,000 cash or surety. Mr. Grant, you have a condition of no contact with the alleged victim. Mr. Grant, I want to be clear that the no contact applies to the adult victim only. I realize that the alleged victim in the child abuse is your child, but I'm not putting a condition of no contact with that child. And here's why. The allegation is that you were allegedly you put the child in a bad situation by trying to take the child from its mother from her home. But the child's injuries happened when the mother grabbed the child's arm. So that they were allegedly not directly caused by you, but allegedly indirectly caused by you. There's no indication that you intended harm to the child. There is indication that you allegedly put the child in a bad situation that resulted in minor harm to the child. So there's not a condition of no contact with your child. There is a condition of no contact with the adult who is the victim or alleged victim in the battery and the criminal mischief and the petty theft. So, Mr. Grant, you'll get a chance to use the phone in just a few minutes, sir. You post that bond, you'll be released. It's cash or surety. That means you can go through a bondsman if you wish. And Mr. Grant, you also will be given a notice for your court date, which should be January 6th at 8:30 a.m. Mr. Grant, do you have any questions, sir?
No, sir.
All right, sir. Wish you the best. Last, we have Rebecca Hours. Miss Hours, good morning. Miss Hours, you're here because you've been accused of violating the terms of your county probation in case 25-52MM. Miss Hours, listen to Mr. McDaniel, your attorney, for today's purposes, ma'am, and we'll see where we go from here.
Your Honor, I spoke with Ms. Hours. She's going to admit that she violated probation, understanding she'll be sentenced to 30 days in jail. She'll have 3 days jail credit. However, she can purge the remaining of the jail sentence after she served 5 days by paying the sum of $988.88.
Thank you, Mr. McDaniel. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Hours, did you hear that agreement, ma'am? Ma'am?
Yes, sir.
Do you have any questions about that agreement?
No.
Ms. Hours, the purge amount is the exact amount you were ordered to pay previously. That's restitution. There's some restitution in there. There's some court costs and fines that you didn't get paid. And then there's cost supervision didn't get paid. So we haven't added anything to it. It's the same amount that you were ordered to pay. Mr. Ham spoke up on your behalf this morning. The original offer was 30 days in jail. Mr. Ham came to me this morning and said that you had went through a stretch of bad luck, became homeless for a period of time, but now you're working and everything's kind of on a better track. So he really didn't want you to lose that job. That's when the purge amount was added, Ms. Hours. Do you think you're gonna be able to make this purge, ma'am?
Yes, sir.
Great. All right. And this is what you want to do, correct?
Yes, sir.
Mr. Mitchell, I think I already asked you, that is agreeable with the state.
Yes, it is agreeable.
Ms. Hours, I'm going to accept your admission that you violated the terms and conditions of your probation in case 25-52MM. But since it's primarily a financial violation, ma'am, what I'm going to do is I'm going to revoke that probation. I'm going to sentence you to 30 days in jail, but you can purge at any time after completing at least 5 days of that sentence. You have credit for 3 days you've already served. So that means in 2 days, you'll be able to make the purge. You can actually make the purge before then if you wish, which I'll talk to you about in just a second. The purge amount is the total amount of unpaid court costs, fines, restitution, and cost supervision. That total again was $988.88. Now, Ms. Hours, here's where it gets kind of complicated. Purge amounts have to be made at the clerk of court's office when they're open. They're open 8 a.m. to 4:30 p.m. So you'll actually finish this 2 days, I guess this weekend, but the clerk's office will not be open again until Monday. So I really don't want you, if you're going to make the purge, the best thing to do, if you have the ability to, is go ahead and get someone to make the purge today. If you do that, the clerk's office will send an email to the jail saying Ms. Hours has made the purge. Please release her when she finishes her 5 days. Then you would get out. Corporal, help me out here. Depending on the math, you would get out Sunday. Mr. McDaniel?
I've advised her all that. You know, the clerk's office closes. The 5th day will be tomorrow. So I advised her that if it ain't, you know, you got to have it paid today if you're going to.
Yeah, that's right. So you would actually, when you serve 5 days, you would get out, but I don't want you to have to stay there until Monday. So just be aware of that. It sounds like Mr. McDaniel's already told you all that. Ms. Hours, do you have any questions?
No, sir.
All right, ma'am. You'll get to use the phone in just a few minutes. I wish you the best. What did I do on Mr. Hall?
$500 cash bond.
Thank you.
No contact with Enterprise.
Thank you. All right. So ladies and gentlemen, that concludes first appearances as far as
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Super Friday. Why is it a Super Friday? Because regular Fridays are for losers, and this is a group of winners, so we do it better. All righty. I've got eyes on Washtenaw County waiting to see if we see anything broadcast for the former U of M coach who is supposed to be arraigned this morning. But I will say the latest thing that was given out there is that they don't have a time for the arraignment, and they haven't announced what the charges are against the guy either. So it's in a holding pattern, but I've got eyes on it. In the meantime, let's go to Texas. We'll say good morning to Judge Stevens.
So I need. Like restitution was $2,000 back in 2016.
I would say it's probably there still, Judge, because this is a situation where he never reported, so.
Oh, he's never reported since 2016?
That's right.
$1,956 restitution.
Are you able to pay that, sir? 1,000, that's the restitution to these people.
Yes, sir. In short time, yes, sir.
No, I'm going to take your word for it. You absconded 8 years, over 9 years ago, almost a decade. Is that right? You absconded, you took off, you flew. You were supposed to report in 2016 to the jail and you never did. Is that right?
He did do 120 days up.
He did do that, yes.
Okay. When was it? What is the period of time that he has been
From his release there on.
which is what date? So we're accurate on.
Yes, sir.
It was in February of 2016.
I'm sorry?
February of 2016, sir.
Oh, okay. February. All right. So that's going on 10 years. In a couple of months, right?
He was actually released from Jefferson County on June 8th, 2016. Your Honor.
Okay.
I believe that's what you were asking.
The last time we saw him was June for his.
He was supposed to come for intake, but he never showed up for intake once he was released from the jail.
Okay. And it's been almost 10 years since his release.
Yes.
Yes.
And he never, oh, okay.
9.5 years.
And so he was placed on probation in February of 2016. But so he must have been in court somewhere in February of 16. That was the last time we had a contact with him?
That was the date you sentenced him for this, Your Honor.
And that was the last face-to-face contact we had with him until he was arrested recently.
He was arrested when? About?
In Harris County in October.
He did have fun. 10/25. Okay. Really, at the end of the day, he's been an absconder, took off for a decade. All right. So this is a state jail felony, right? I guess.
Yes, sir.
And he hasn't paid anything to these poor people, and he has nothing to pay.
He stated that he has he's getting Social Security, I believe, and that's how he was able to live.
Do you have the ability to pay restitution? Brand, here's what I'm going to say. No on this deal. He gets 2 years, as far as I'm concerned. He gets 2 years. I mean, what really? He took off for a decade. I mean, why isn't this one of those where you get the max? What message do we send if he doesn't get a max? If 5,000 people on my docket took off, and then when they came back, they're going to say, I want the Trumba rule. He didn't, I don't want to get severely punished here, even though I walked off the job and didn't pay anything. And for a decade, y'all had to find me. Okay, I got found. Now I'm going to make a deal. No, that's not the message I send. We've got him. We got a hold of him. He's going 2 years, and he's going to go do the full 2 years, as far as I'm concerned. That's it. Now, you don't have to agree to it. We'll just set it for a hearing. That's what we'll do. But he's not getting. Are you kidding me? I feel sorry for the poor victims who hadn't gotten a dime since you fled. The message we would send is, yeah, do all of this, flee. If you get caught in a decade, we'll make a deal. No, I'm not going to do that.
Well, just so that the court's aware, and I don't know how, he did make phone calls, and I think Mr. Menard would confirm this initially from Harris County saying, I need to transfer my probation to Harris County. He was unable to get back to Jefferson County to actually report. He informed the probation officer of that. It wasn't Mr. Menard, of that fact, and he tried to work with it, but apparently the state didn't really care about it that much and let it go. And so clearly they haven't thought too much about it. Well, I mean, 10 years.
Okay.
Yeah,
But it was the court's order. We're talking about the court's orders. Y'all are working things on the side, and that didn't work. That's not important to me as the court's orders that have to be followed. And sometimes they can't be, but then I get the court, if somebody comes to the court, it was my orders that we made based upon our hearings and what evidence was presented in due process. But these side deals, that's not as important to me after I made my order. I need to be in the loop. Y'all I know y'all are trying to work things out, but this is atrocious. I mean, really, anybody who sees this goes, you can flee, you can flee if you get caught in a decade. You don't have to pay your restitution back. We're going to make a deal of whatever it was. Y'all are going to make what? I don't know. What was the deal?
18 months.
Yeah, 18. Yeah. And
I'm not asking you to approve it, Judge, but I do want you to know that I got to that number because in that 10 years, there was not a new criminal offense. And again,
every day he's committing a crime.
Yes, sir. And Judge, I love your philosophy on this. I'm not disagreeing with it at all. My thought is in that 9.5 years, if he actually wanted to report, he could have made it here. I'm in the same boat with you in that regard.
Well, when they come to me, it's good for everybody. I set a standard by what I do. It's what's the people say, is it fair or not? But in your circumstance, you had more than enough time in a decade to take care of this business on your own. We had to get you.
Yes, sir.
And sorry, there is nothing but bad on this. There's nothing good. It's all bad. And then the poor victim, if I was the victim, I go, okay, so he's going to get some time. He doesn't get maxed for being gone fleeing for a decade and hiding out and then being caught. But then I'm out $2,000 and he didn't even have to pay that. That doesn't seem right.
We can be ready whenever you want to set it for a hearing, Judge.
Yeah, I'm sorry, Mr. Trumba. That plan is not fair. And what's fair is what you have done is whatever the law, whatever is extreme under these situations, you deserve it because that's what you did here. You deserve the maximum. And it wouldn't be fair to everybody if you didn't. I'm not going to set a standard where you can flee for a decade, not pay anything back, and then come in and make a deal of something less than what the statute maximum was. Now, if you can find a way to pay these people back quickly, well, you're not going anywhere, but I never let you out. But if you can get somebody to help to pay this back, I will reconsider this whole thing.
Okay.
I will, because I want these people paid back. And that's another equation that you're going to get a deal. And and for all of this? It's no.
It's a bank, right?
So
I believe it's.
do you have any contacts, anybody who might be able to help you on this?
Yes, sir. Yes.
Okay. Why don't I then reset it a week and see I don't know if that's going to be enough time, but I can reset it a week.
Enough time to.
I can reset it for any length of time,
How long do you need?
but you're not leaving anywhere until this gets done and these people get accommodated. And then I'll be willing to go forward with the plan. But
How long do you need, Mr. Chairman?
might be a little longer.
What's a little like? I give it.
Why don't we bring you back next week and see where you are and everything?
Thank you.
Okay. Review then, Judge.
Yes, sir.
Okay.
All right. Reset it.
Come back in here.
Well,
Okay. There should be Mr. Paget, Mr. Wilkerson, Ms. Holmes, Mr. Eckert, Alex Comerford, and then pro se people. Where's everybody?
Wilkerson sent us an email this morning who was ill and wouldn't be there. Wanted to reset his case. Ms. Holmes's case.
Okay, please bring Joseph Castillo out. We'll tell him why he's not having his hearing.
Brittany Holmes, that case was reset because they just filed a first amended MTRP. So they have to have time. That Mr. Comer called in, said he's running about an hour behind. And I haven't heard from Mr. Patrick.
Paget's here somewhere.
Okay, all of these, let's reset them for a week. Okay, because these are dispositions. I don't want to go to the holidays.
And Mr. Eckert is here. I think he's in the back of compliance.
Oh, so Castillo, I'll do it a week. Wilkerson's deal. Let's see.
Yeah.
And you said Comerford's on his way?
Comerford is running an hour behind. Apparently it's flying in and they're waiting on the visibility from the pilot. So.
Okay. Who are you?
Joseph.
I'm sorry.
Joseph. Steve.
Wilkerson's got.
Okay, Marcus Wilkerson is unable to be here. But we're going to reset this just until next week so we can figure out what's going to happen. This is an MTRP hearing, and I want to dispose of this one way or the other before the holidays. So we're going to have to reset for next week, okay? Thanks, Mr. Christie.
Still stunning is in the back. So it's going to get out of the end of
Thank you.
Alrighty, friends, I'm going to keep an eye on Judge Stevens. We'll wait for him to rack up the next contestant. In the meantime, let's go to Lake County, Ohio. Judge Collada, see how his Friday's going.
Good morning. Good morning.
All right, we are present in case 25 CV 542. Gregory Rivenbark versus Lauren Hall. Scheduled for non-jury trial. Plaintiff's complaint seeking partition. You're Nicole Cruz?
Yes, Your
And you're
Honor.
here representing the plaintiff today?
That's correct.
Mr. Rivenbark?
Yep.
Okay. And you're Ms. Hall?
Yep.
You're representing yourself in this matter?
Yeah.
You can take your coat off if you'd like.
Yeah, I'm always cold.
All right. Well, both sides prepared to proceed?
We are, Your Honor.
Ms. Hall?
Yeah.
All right. Mr. Cruz, I'll hear from you first. Any opening comments you care to make?
Sure, Your Honor. Your Honor, in this matter, we did file a complaint for partition. The parties were in a relationship. They were engaged, purchased a home together. After the purchase of that home, the relationship ended. My client has since vacated that home, but he has continued to pay the bills and expenses associated with the home while the defendant is residing there. The parties have been unable to work with each other to get the house listed or sold or bought out, or any type of remedy in which the plaintiff can get his interest out of the home, as well as the expenses and funds that he's been paying since their separation.
Why is he still paying them?
Well, his name's on the loan, so if it doesn't, it affects his credit.
Fair enough.
So he's trying to preserve the asset, and he would like to get his interest out. The only option to do that would be to have the house listed and sold, and then for him to be reimbursed for the payments that he has made while she's continued to live in the house without paying those expenses. The testimony and evidence will show the copies of invoices and all of the bills that he has since paid, and that those total expenses are just over $41,000, Your Honor. So he is seeking reimbursement for those expenses as well as the division of the total proceeds after the house is sold.
Now, your complaint that you filed references exhibits A and B, but there's no exhibits A and B that were ever filed, attached, nothing.
I do have those as part of the exhibit.
And there was no decree, no evidence of the state of the record that was filed at the time the complaint was filed, which a local rule requires?
I'm sorry, I did not hear your question.
It wasn't a question, it was a statement. There was no, the local rules here in a partition action require that some evidence of the state of the title of the record be filed at the time the complaint was filed. There's nothing.
Oh, it was intended to be attached, and I didn't realize that it wasn't attached until you said that. I would ask leave to supplement to add those attachments that were referenced, and I do believe that the defendant's answer does admit that it is jointly titled home.
All right, thank you.
Thank you.
Ms. Hall, care to make any opening statements?
No,
So you're here contesting this today?
no.
So why haven't we agreed to sell this property?
I have a proposed entry, if she's willing to sign, that says they will list and sell it.
I mean, here's the deal. If we have a partition and I find that it's warranted, the property then ultimately goes to sheriff's sale, which doesn't bring in as much money as it would if it was on the market by a realtor. So it makes sense to do it without a court order and sign a contract with a realtor or try to sell it on your own. I'm not saying you have to use a realtor. You can try to sell it by owner if you wanted to do that. But if it goes to the court, it's going to be a sheriff's sale, which is like a foreclosure. Now, that doesn't mean your house is being foreclosed. I don't want to mislead you there, but it goes to sheriff's sale, which you don't get full value for. So I'm assuming both parties have some interest in this property?
Yes.
So you have an interest also?
Yeah. It is.
And I'm only talking about the partition portion of this action here and the sale of the house. If there's another cause of action, which it sounds like maybe there is, though I don't believe there's anything else that was part of this complaint. I mean, you said
The prayer for relief does request reimbursement for his payments of the expenses. But I do agree with you, Your Honor. It is in the best interest of both these parties to list it with a realtor and sell it because they will get maximum value out of the home that way.
I agree too. But that's not, I mean, if I'm going to get involved, that's not going to happen.
I have a proposed entry if she's willing to.
So, do you understand what I was saying at all, or not? I mean, I'm not trying to belittle you or anything like that. You obviously don't have a lawyer with you today. If you don't agree to sell the house, the way the law is, if there's two parties that own a house and they can't agree on it, it goes to court. And if the court finds that this property is not divisible, which a house is not divisible, means you can't split it in half. Some property, if it's just land, you could split it in half and you can keep half of the land, and he could have the other half and do whatever he wants with it. You can't do that with a house.
Right.
And if I make that finding, which it seems like that's what would happen here, I mean, I'll listen to the evidence, but if we have a house, and there's two people that can't agree on what should happen to it, the partition must be ordered. And if it gets ordered, I'll explain what happens is I'll appoint what's called a commissioner. A commissioner will be a real estate agent here in Lake County who will go out to the house and give me an appraisal of the house. Or she give me an appraisal of the house. They'll give me an opinion as to whether this house can be equally divided, which, assuming you can't cut it in half. It's not a duplex, I'm assuming, where there's two. So they'll give me that opinion that it can't be divided. And then, once we get the appraisal, each side has a right to purchase it for that amount. Once whoever comes to the court first will get the priority over that. If nobody does, then it goes to sheriff's sale. Is either party interested in buying out the other person?
My client is not. He had to secure other housing when he went.
Are you able to buy out?
No, I'm
Okay.
not interested in doing that.
Well, then I would assume that once the appraisal is returned and the court issues an order saying, here's what it is, either side has, I forget exactly what it is, but say it's 14 days, I think, to contact the court and let them know if they want to purchase it. After 14 days, I'm not going to hear from anybody, it sounds like. And then I send it to sheriff's sale. And at sheriff's sale, there's some bare minimum that it has to bring back, and I don't know what that is off the top of my head, but it's not going to be the full value. Not going to be close to the full value. But that's what it would sell for, and then those proceeds would be divvied up between the parties with whatever expenses one side's entitled to from, so if the plaintiff's entitled to expenses that he's incurred, he would get that out of those proceeds as well. So that's what would happen. Now, but you could also agree with the plaintiff to put the house up for sale and go that route. I'm not involved in that route. What did you say you had prepared?
Your Honor, I prepared a proposed agreed judgment entry saying just that they'll list it with a real estate agent. Neither will commit any waste or destruction on the house. They'll cooperate with the real estate agent, and the sale proceeds would be divided, but from the share he'd get his reimbursement of those expenses back.
Well, the expenses that he has paid.
Yes.
I'm not making a statement. I guess I'm asking a question. But has he paid? Like for example, what has he paid?
The mortgage.
The full mortgage?
Yes, each month, as well as utilities, homeowners insurance.
You haven't paid anything?
I paid the bills that have been in my name. He hasn't contacted me to switch anything over or.
Well, you can't just. You just said you can't afford the mortgage.
No. When he left, I didn't have a job at the time. I was on disability for a while, and then I was looking for a new job.
But what do you mean he didn't switch the name over? Like what the name of?
Or just like how any of the bills were set up. Like even after I had a job, everything that was.
But there's a mortgage. You just can't send.
I'm just paying like internet, the gas bill, any paper bills that come for like sewer, water. I was paying, but everything that was in his name, he just continued to pay and didn't contact.
Which would be what you said? The mortgage, insurance.
Mortgage, insurance. There were electric bills, water bills.
Even to this day, the electric bills and water bills.
HOA. That's correct. That is correct.
when we had the conference, I had mentioned to his lawyer that I was willing to take over payments and bills, but she said that he didn't want to agree to that or wasn't interested in that.
That was not our discussion. You said you didn't want
Hey,
to.
you're talking about taking over the payment of the mortgage?
It's in both of their names. I mean, she could
Right.
just pay it.
Was that?
It's in her name as well as his, so she could have just paid the mortgage,
Right.
which hasn't happened.
He's not just gonna let. He owns half of this house. I mean, you're paying the mortgage. That's not gonna resolve this.
No, I understand. I was just saying while I was there until we sold it. Because I was trying to push the sale off until my daughter's school year was over. So I just brought that up as an option to see if he was
I do
interested.
remember something to that effect, to be honest with you. Something about the school year being over. I don't.
She did say that in the conference, and that was the part that
And
I
then-
objected to, because at that point, it would have been almost, 8 months.
Yeah. Well, I guess, Ms. Hall, the ball's in your court. I don't know what you want to do. If you want to agree to list this with a realtor, I'm not involved in that. You would.
Yeah, I'm okay with that.
So the amount that you're requesting, because there's two issues here. Are you saying that that would be paid out of the proceeds? She's not expecting her to write her a check.
That's
her
correct.
to write you a check.
That's correct.
Is it the full amount of the mortgage or half of the mortgage? How'd you calculate this?
In my proposal, it's the full amount back to him, because she's continued to live there without paying these expenses. He's had to pay that expense plus all of his own living expenses, which has created quite a burden for him.
I didn't ask him to move out though. This is another.
We're not gonna litigate. That's upstairs, but
Well, they don't make it up there. They weren't married. That's why we're here.
I get it. But I'm just saying that's an issue that would. Yeah, I guess I'm not going to weigh in on that. I mean, if she has, that's up to Ms. Hall to determine that part of it, I guess, or counsel. You're not going to have an attorney, you said? You're representing yourself?
Yeah, I can't afford one.
Well, I guess I don't know if you want to sit down with plaintiff's counsel and go over that and see if that's something you want to agree to. I'll take a break here and you can review that with her and see if that's something you want to agree with her or negotiate with her. What help you to do that then? All right.
Okay.
You can do that in here. I'll get out. You guys can use the courtroom. We'll.
Okie dokie. I guess they're gonna try to figure it out themselves. This was a bit of a waste of time for the court, in my opinion. You let me know what you think in the chat, but adults not being able to adult. You bought something together, you broke up, figure it out, sell the thing. Work together, get it done, and move on with your life. Instead, we're going to go to court. I don't know. Doesn't make sense to me, but, maybe it's just me. Let's go back to Judge Stevens, racked up a new contestant.
One of us are looking to drag this out.
Thanks. I was just, the question was, for 2 years and 3 months, what happened? And there was nothing.
She's in Houston
We just
now.
had one announcement out, all that.
She has taken herself out of this environment here. She's going to college in Houston right now.
I was just curious about the whites, who dropped the ball on that, but they just couldn't find
But
it.
I assure you, we're not going to trouble. Yeah, I've got the ball now.
Yeah. Yeah, we said 4 weeks. Thank you.
I'll carry the ball across the finish line here. How about that? That's a torch. Something like that. A torch ball, whatever you want to call it.
All right. Shannon Ardwan, tell me about this one. Sister Ham. Bring the defendant out, I guess. Process.
What I'm telling you is, we'll come back here.
Where we're at with him is we're in the discovery process. He's been given all the written discovery,
Make the trip back.
and we're in the process of the media discovery. And Sonny had, when he had the case, broke it down, and
He's not representing him. This guy's representing himself.
he's representing himself, and he's had 2 days where we reviewed a bunch of media, And I've got proof about that. Hang on, Judge, before we bring him out, I just want to let you know, I've got to get upstairs and get another thumb drive with media so that he can review that. Right now,
How's he doing that? How's he doing that?
It's gotta be set up
You give him
where
the thumb drive and then it's in the jail, they make something available?
no, sir.
You have to do it here?
Yes, sir.
Okay.
That's my understanding. I sure would make it a lot easier if there was a different way to do it, but I understand he's been reviewing it in the jury room.
Okay, do I need to bring him out right now?
I'm just asking, let me get what I'm gonna have available for him to review today before we bring him in. I do want to cover when he's on the record what he's seen as far as in May. There was an opportunity there he was given to review some documents in July, but that thumb drive didn't open up. So that's why we're trying to make sure I've got it in a position where he can take care of it. Give me just through. Anything?
I don't think we need to bring him out. Do you want to bring him out?
What are we doing?
It's still going to be a trial.
Okay. Yeah, yes. Puente?
Once I'm done with this, I'm gonna get that stuff from Mr. Ardwar.
All right, good. We call 25 CR 263, the state of Texas versus, we have it, hold on. Versus, is it Daniel Carmona Puente?
Yes, sir.
All right. And Mr. Puente does not speak English fluently? All right, so we have an interpreter here. And please tell us your full name, ma'am, for the record. I know you, and then I've got to swear you in so that as an interpreter for this hearing.
Yes, sir. Erica Burge.
And we know Ms. Burge as a fluent interpreter, speaks fluent English and Spanish. Raise your right hand. Do you solemnly swear or affirm you will properly and correctly translate English to Spanish, that the language your client understands, Mr. Puente understands? You will repeat his statements of Spanish into English for the record. You will do that correctly. So help you God.
Yes, sir.
All right, Lois. All right, go ahead.
Judge, we previously had this case set for trial.
Yeah, why did we take it all?
I asked for it to be set today so that I could speak with him.
Okay.
In an effort to figure out where he's at on the case and whether or not there was any conviction possible.
Okay. He's charged with burglary of a habitation, which carries with it up to 20 years in prison if convicted. And where are we on the attempts to resolve it without a trial?
Mr. Hammond's made an offer of a deferred adjudication probation.
And he's not accepting that?
Correct, Judge.
Okay, and that is odd. The court will generally, defendants closely consider deferred or unadjudicated probation since those are not readily given as an opportunity, and deferred is something where the defendant will not be found guilty so long as he follows terms and conditions of probation. Most of those terms and conditions of probation are the rules that all of us have to follow, like don't commit a crime and don't become intoxicated and don't take care of your personal business and your family. Those are rules that we all are required to follow. So when somebody turns down deferred or unadjudicated probation, that's rare. I'm just curious, what is the reason he would do that? Now, he certainly has a right to a jury trial. That's what the Constitution stands for. But deferred or unadjudicated probation also allows a defendant to be released in 1/3 of the time of probation if the defendant does well, and that's what the court does regularly. And I don't know if he knows that or not, because if it was 10 years probation, he could be released in 3 1/3 years and move on with his life if he did well.
So we were able to talk about all that today, Judge. And I can say that we have thoroughly considered it. In this case, I do believe that there are issues suggesting factual innocence.
Okay, well, if he goes to trial, he doesn't get deferred or unadjudicated probation by a jury. That's not allowed.
He understands that.
And they would either acquit him or convict him. And if he's convicted, he could go to prison for up to 20 years. If they grant probation, it's a conviction. And it is seldom erased.
Yes, sir.
When you were finally convicted. He understands all of that.
Yes, sir.
You understand all of that. Okay, then as long as he intelligently and voluntarily weighs the issues, it's his life. He can make the decision he wants, and we will set this for trial and try to get this as soon as we can get to it. Okay?
Thank you, Judge.
That's what we will do. And there are I won't accept a deferred or unadjudicated probation offer after today. So,
I understand.
Okay, we're going to trial, and that's the choice he makes. And he won't be, the court will not allow deferred or unadjudicated probation if he turns it down today. Okay.
Yes, sir.
Thank you. That is all.
Thank you.
Next.
This is, I think this is an actual.
All right, well, we keep an eye on that to wait for another contestant. This isn't a judge I've gone to before, but I believe Michael did when he was guest hosting. Let's take a look at Judge Molly Hennessy Greenwald. This is in East Lansing, Michigan. Let's say good morning to her.
This is case number 25-1087-FY. We're here today for a probable cause conference, and may I please have your appearances for the record?
Good morning, Your Honor. Jeremy Bear, Assistant Prosecutor for the People.
And thank you, Your Honor. Jonathan Foreman, Office of the Public Defender, here with Mr. Burns, who is appearing from the Ingham County Jail. We waive any in-person appearances this morning. And I think I might be frozen.
I think you might be too. I could hear everything you said, Mr. Foreman, clearly.
I can hear you as well. I apologize, Judge.
Okay, it's okay. And I see Mr. Burns. There you go. Now you're back, Mr. Foreman. Mr. Burns, you're muted. As soon as you're unmuted, if you could please just confirm that you can hear and see us. And we've got Mr. Foreman back here.
And I think he just gave us a wave, Your Honor, and I think that is confirmation he can hear us, but of course he's still muted.
Okay.
Yep, I can hear you.
There you go. Thanks, Mr. Burns. Mr. Bear, how are we proceeding today?
Your Honor, for the record, there is a plea deal on the table. The plea deal is plea to larceny for less than $200 under MCL 750.3565, plus restitution for the alleged stolen property, in this case, some psychiatric pills. I defer to Mr. Foreman as to whether or not he's taking that plea deal.
Mr. Foreman.
We're going to leave it on for preliminary examination at this time, Judge. There's some additional investigation my team is doing. But we're not rejecting it or accepting it today, just leaving it on for preliminary at this time.
Okay, we are set for a preliminary examination next Thursday. That's December 18th at 9 a.m. Mr. Burns, you heard everything that the lawyers told me, correct?
Yep.
Okay,
Yes, I did.
so you understand what's happening today is that the parties are putting on the record a plea offer. Mr. Foreman, your attorney, is saying, I'm going to do more investigation. I'll be talking with my investigators and the client, and we'll determine by the date of unless the prosecutor has another deadline where the plea needs to be accepted, Mr. Baer? Is it open? Is the plea open until prelim?
Yes, Your Honor.
Okay, at least. So with that, we'll be back together. I would just ask that the parties inform the court, we need to know if Mr. Burns needs to be brought. So probably best practice, Mr. Foreman, to just schedule transport and then it could be canceled.
Yes, Judge. So I'm in trial Monday and Tuesday, but I'll do my best on Wednesday to inform the court of any updates as it relates to whether it needs to be brought. And I'll just do that when I have that information.
Okay, and then of course that goes the same for Mr. Baer and any witnesses.
Yeah, yes, Your Honor.
Okay, so very good. We'll be back together, seeing you one way or the other, or perhaps should we just say that Mr. Burns should be brought? If it's going to be a plea, he would be here in person. Or how would you like to do that, Mr. Foreman?
I would prefer he be brought, and I'll inform the court if something that doesn't require or obviously I'll inform the court in advance regardless of how we're intending to proceed. But if it's something that doesn't require his presence in person, then we'll make those arrangements with the court.
Okay, very good. So Mr. Burns, are we all clear on what's happening here?
Yes.
Okay, very good. Well, I look forward to talking with you more, and we'll have more information next week. So thank you all, and that's all for this case.
Thank you.
Okay, I have no one else for Mr. Foreman at this point. I'm going to put you both in the waiting room while we do an AG case.
Thank you.
You're welcome. And
Okie dokie, looks like they're going to do whatever they're doing next. Well, I don't know. I'll keep an eye on it. They're racking something up, but let's go back to Judge Stevens for now. And he's muted himself. Let's bump him forward a little and see if he finds his unmute button.
I can have it ready next week. The problem's going to be that availability for him to review it. And it's, I believe,
during the trial.
Correct.
We're going to be having a trial, but we'll figure it out.
Okay.
We'll figure it out.
I've got some good checklists, and I'll go over it with you.
What does it take, friend? Where does he need to be? I'm
my understanding
fuzzy about how this is practically working.
We've been doing it in the jury.
We need the jury room.
Yes, sir, but we have to have somebody in there with
We need
him.
to
Understand? Understand.
That's what
the logistics.
we're not.
Well,
they're different than what we're used to.
we probably won't need the jury in the jury room until Wednesday or Thursday.
So in theory, Judge, if you've got a jury trial going on out here, you won't have the security be able to be with him in there to do that.
Have an extra person available to help on this.
That might be doubtful, Judge.
Yeah.
We could try.
Can we see what we can do? Thanks.
If nothing else, we'll have to downweed.
My goal is to get this information to this man next week.
The jail, is there any kind of way to review it at the jail? No one's there.
Not really.
Monday and Tuesday is going to be impossible unless the DA provides their own officer. But Monday and Tuesday is going to be impossible for us Because we're already getting.
What,
text
okay,
messages.
what about Wednesday?
Wednesday and Thursday were probably more sufficient.
Can we try to work on Wednesday? Work it out for Wednesday?
I'll let us.
Okay, I'm gonna set him to come back up on Wednesday. And we're gonna get it done one way or the other next week, but that sounds like the earliest.
The only problem with that would be is if the trial if it's a quick trial, then you might have to deliberate by Wednesday and Thursday.
We don't know until Monday, which trial out of the group.
If we set it and if we are at a point where we do not have the
Let's set
availability
him,
of the room, we
I want to bring him in Wednesday so we can know one way or the other, and then
Yes, sir.
we'll get it next week somehow.
May I ask him one more question,
Yes,
Judge?
sir.
So when Mr. Eckhart was working on it and you reviewed it those 2 days, did you see that, what he called a media sheet?
I have one.
All right, so, okay, good. So you've seen and you know what you've seen and not seen.
Yes.
Good.
You know what-
I wanted to make sure.
You know
And I
how
will-
that works, that
Right.
media sheet.
And I'm gonna I'm working on a copy to make that available for the court's record too. So, good. Thank you.
I know in the past they have done, bring the media to the jail and did it there.
Let's figure out, I've told him he's gonna get it next week. Let's figure out how we can do it.
That would be the best convenience because they have these.
We're gonna get the jail on board with what we're doing here right now, it's not.
Yeah.
Well, we need to talk to them out there, get the captains involved, and maybe the sheriff. And get them to step up, because they're not doing it right now.
Okay, all right.
I'll let them say.
They do have the room for that as well as, for the, legal research, access to courts.
What is that room? Is that what that room is normally used for?
No, it's normally used for arraignment.
Okay, so it's on,
But it has.
when it's not being arraigned, it's free.
Right.
When there's not arraignments there, all right, well, we'll bring him back Wednesday, see, hopefully.
What's that?
That we can get it, but our goal is to get it done next week. Okay, thank you, yes. And we've got Alex Comerford on Jadarius Hamilton we're waiting on, right?
we're in an hour behind.
What is the plan on this? Do you know, on this case? It says an announcement. I mean, he's gonna fly in to say trial and then fly out, I guess?
Judge, you may want to call.
Well, we'll let them sort that out. Let's go back up to Michigan, but we'll see what's going on with Judge Elmore. He's in Missaukee County Courtroom this morning.
We are on the record this morning for the 28th Circuit Court here in Missaukee County. And we're going to begin today by taking up this case, People in the State of Michigan versus Kelsey Jacqueline Sims. This is file number 25-3596-FH. Appearances from counsel first.
Thank you, Your Honor. David Denhout on behalf of the people.
Good morning, Judge Ryan Niegos appearing on behalf of Ms. Sims.
Thank you. Mr. Nagos appears today via Zoom. And also here before the court is Ms. Sims, the defendant at defense table. She is currently in pretrial custody. We also have with us this morning Mr. Luke Blazak. He is an agent from the Michigan Department of Corrections. And we are here today for a sentencing in this case. The court originally received the pre-sentence investigation report back on June 26th of this year. The case was originally set for sentencing on July 7th of this year. Mr. Blazak, I just want to make sure, did you do any updates or anything else add to that?
I didn't have any updates.
All right. So the first thing we'll need to do is obviously change the date of the sentencing. And then we're going to need to turn back to CFJ 145, page 2, and account for the further days of pretrial credit. So we need to find out from our file here when Ms. Sims was arrested on the bench warrant. I think we did that back on December 1st. Is that right? Or did she get picked up before that? I think that was it.
I think it was November 26th.
November. Hold on. Let me take a quick look. So I issued the bench warrant, an amended one at least, on September 12th. And it also says, let me say, no, I should say that according to the file, we see that this court dealt with a bond issue on December 1st. Madam Clerk, do you have anything on the computer there? It tells us when she was picked up.
I have that we did an arraignment on 12/1.
Okay. Mr. Blazak, do you have any idea when she was actually arrested? I want to make sure that was arrested on this file, and if there isn't any other file out there. Let's see. They can get information. So.
I was in jail for Thanksgiving.
Okay, so I'm just going to accept because nobody else is going to tell me yet. We're just going to say that she was picked up on November 26th. Does that sound right, ma'am?
Yes, sir.
All right, so we'll put a new date range of 11/26/2025 because she'll already get credit for today. We only give credit through yesterday, which puts us at 12/11, so it gives us 15 more days. Sound about right, everybody?
Yes, Your Honor.
All right, Ms. Sims, Draken. All right, so we're going to put an additional 15 days. That's going to be added to the 19. That's going to give us 34 days of credit. Any objection to that, Mr. Denhoughton?
No, Your Honor.
Any objection to that, Mr. Niegos?
No, Your Honor, thank you.
All right, great. Thank you very much. And of course, that 34 days of credit will have to be changed on CFJ 145, page 1 and elsewhere throughout the report. Now, I'm going to continue to look to see if I had any other amendments or corrections here. As I often do, I go to the adult criminal history, and we're going to look at CFJ 284, beginning on page 1. We see in that file that there was an arrest on October 17th, 2009, with a conviction and sentence on November 25th, 2009. Which means that for entry 3 of 15 on page 6, she must have been on bond. Make sense, Mr. Blazak?
Makes sense.
All right, good enough. Thank you. Then we're going to keep looking. Didn't see any other need for changes therein. Now, there are a few things here that we might have to do some additional changes, but we're going to talk about that because I have some other issues, but we're going to talk about changes now with the prosecution. Mr. Denhoughton, any other objections, amendments, or corrections to make on behalf of the people?
Thank you, Your Honor. I have reviewed the report and I have no proposed corrections or additions.
Thank you. Mr. Niegos, any other amendments or corrections on behalf of the defense?
No, Your Honor. We've also reviewed the PSIR and we believe the sentencing guideline scoring is accurate.
Right. Thank you. Allocution then, Mr. Niegos.
This was a difficult case, Judge, insofar as, in my interactions with Ms. Sims, she's been focused on rehabilitation. Unfortunately, Mr. Blazak report does accurately summarize some of her conduct while out on bond, while attempting the rehabilitation. And unfortunately, I think the court is probably too familiar for its own liking in terms of the ebb and flows of people that battle addiction. And how that affects some of their choices. In talking to her recently in preparation for today's hearing, she remains focused on that. She's once again made contact with the Sunrise Center. She does inform me she's serving a separate sentence for some misdemeanor offenses through Wexford County. Her release date is February 8th, 2026 on those offenses. She's hopeful that she will have an opportunity to re-engage in rehabilitative substance abuse services through Sunrise Center as an inpatient client after that February 8th, 2026 date. In addition, having the benefit of sort of looking around the courtroom via Zoom, Judge, I can also tell the court that she's been, I'll just say this, she's been very cooperative with members of law enforcement since she's been detained in the local jail on some other matters. My understanding is that cooperation was appreciated. And regardless, ultimately, she understands that, she's got a checkered past. This is now an additional felony conviction. And anytime you start trending towards a total, more or less hit count, if you will, approaching 20 prior convictions, that's certainly concerning in terms of her ability to remain free should there be additional contacts with the criminal justice system, certainly in the felony land, as her guidelines would go clearly away from any type of presumptive no jail sentence. So we would ask that the court consider the totality of the information in the PSI and fashion a sentence that the court deems appropriate when balancing rehabilitation, deterrence, and the punitive effect that it must take. We would also ask for the court's grace in considering if additional incarceration is necessary to perhaps consider keeping her there or thereabouts with her current release date of February 8th, 2026. Thank you, Judge.
Mr. Diego, she mentioned that there were some other issues that she's had over in Wexford County. Did she enter pleas or something? Was that taken care of in the district court over there?
My understanding is yes, Your Honor. She is currently serving time for a malicious destruction of property charge and perhaps an attempted RNO as well.
All right, thank you. Mr. Denham.
Thank you, Your Honor. The underlying incident occurred back in December of last year. The defendant was on supervision at the time. There was a compliance check, and she was found with some narcotics.
I was not on supervision.
It was a tramadol.
Right, he just said that I was on supervision and I was.
Oh, I'm sorry.
I was at somebody's home who was on supervision.
I got it.
I'm sorry for
It's okay.
interrupting.
I think it's all right. Go ahead.
I appreciate it. It was a compliance check. I perhaps misspoke for another individual, so I apologize for that.
It was Mr. Ealing.
In any event, I accept the correction.
Which, by the way, Mr. Blazek, when you put in a person's name right after their address, if their address ends with the word drive and you just put DR, it looks like you're saying that Mr. Ealing is Dr. Robert Ealing. I had to keep shaking my head. I'm like, I'm pretty sure I've never heard of him as a doctor. All right, go ahead.
Yes, Your Honor. So the people, obviously, we would never penalize someone for exercising all of their rights and contesting all matters. We would never consider doing that. But to the defendant's benefit, she acknowledged that she did have narcotics. She pled guilty. Also, when the bond violations came out, she also acknowledged the difficulty that she's been having. So I think that can be stated on her behalf. She has been struggling. The initial plea was to the possession of analogs. There has been a series of bond violation. I know the recommendation now is for a straight jail sentence. We understand the reasoning why that recommendation exists. We support that recommendation, and we would leave it to the court for the exact term of any additional incarceration.
All right, thank you. Ms. Sims, you have the right to make a statement if you so choose before the court issues a sentence. Is there anything you wish to say today, ma'am?
Your Honor, I would just like to say that your mercy was not extended in vain. I had 1 week left of treatment and I got into a verbal argument, which caused me to be released from the treatment. I managed to stay clean. I'm clean to this day. I did not indulge back in drugs. I started going to a revival center and became part of the celibate recovery. I maintain a job now. I work with Made in Heaven and Roscommon cleaning houses. And I also have been going to church occasionally with the owners there who are part of First Presbyterian in Cadillac. So I did make some significant changes, although I do take accountability for you extending that mercy to me and me failing. Like that was, I still hold that as a reminder in my head today that I don't want you to think that your mercy was extended in vain. I'm just grateful for your time today, and I do take accountability and I accept whatever punishment you see fit.
Thank you. Well, I don't want to forget it. The one comment you made, nothing about today is personal with me. All right. I understand that addiction is a difficult problem and challenge for people. Nothing about this is about me today. Now, the next thing I want to talk about is, and I don't mean to do this in a rude way, Mr. Blazak, there's something wrong with this report. There's a lot wrong with it. All right. And so I'm going to walk through it, and I'm just going to ask you some rhetorical questions, a little bit like Socrates here, although I wear a white robe or a black robe. On CFJ 145, page 1, there's something that's missing at the bottom. What is normally at the bottom of that page? The answer is drug history. Now, here's why that's a problem for me in today's case. And then when I turn and I look to CFJ 284, page 2, underneath the compass chart, it says for substance abuse, highly probable. Then further down, when you talk about the compass narrative, it says she's likely to have a drug or alcohol problems and need substance abuse treatment. But now I'm starting to think, well, how come there's nothing on that first page to detail the drug history? Well, then that continues because there's some other inaccuracies here. Because then when I get to CFJ 284, page 13, it says underneath substance use and treatment, it now says no substance abuse history found for the defendant. So now I start scratching my head wondering, well, geez, why wasn't there a list of drugs on CFJ 145, page 1? And then I wonder, why does the compass score and comments talk about her having a drug abuse problem? And then I get back to this page and it says, well, she doesn't have a drug abuse problem. And then I wonder, well, then I go to look at her criminal history. In 2013, she had a conviction for morphine. In 2016, she had a conviction for fentanyl. And in 2018, she had a conviction for meth. And there's another problem, and that is and here's what I'm trying to convey to you. Especially when somebody has been gone for 5 months, you need to do an updated PSI, because it also doesn't include the fact now that I know she's got other convictions while she's been on my bond or the court's bond. So when I look at this report, I put down a note. The sentence I wrote down, the sentencing and the story told here are incomplete and inconsistent. Because why would I or this court or any court send her and allow her to do rehab and then find out she violates rehab and to find out she needs rehab when the report, half of it makes it sound like she has no drug problem or drug history. So there's a lot here that this report is not done well, and it needs to be updated. So I told you earlier when I asked if anybody had any changes, and I said I was done. I was going to wait till later to talk. Well, this is the reason why, because it's incomplete and inaccurate. So the court, though, will continue and proceed with sentencing. Now, Ms. Sims, we've already talked a little bit or talked around it. Your performance on bonds has not been good, and you have left programming when the court lets you go there. When again, you talked about it being grace, and I appreciate that. That's what it is. It's a grace to allow a person the chance to go prove themselves. Well, in here, you were removed from one program. You revoked your waiver so community corrections couldn't find out where you were or what you were doing. And you failed to keep community corrections informed of your whereabouts. And you were not cooperating well with your PSI, which may contribute to the inaccuracy of the report. So there's a little bit of blame all over. And so that's why, to me, today's theory or theme about this file is the story in this report is incomplete and inaccurate and nonsensical. So let's take a look here at the crime. The crime was relatively minor. You had, it looks like a pill or two of this tramadol, and you called it medication for your dog. I don't believe that's what it was. I don't know of many dogs getting prescribed tramadol, but the fact is, if you want to take that, then my thought is, well, then your problem, your substance abuse issue is so strong that you're willing to take dog medication. But we all know that tramadol is often used for adults in certain circumstances. So then I looked at the history. Back in 2008, she had a couple, you had a juvenile, 2004, a juvenile history adjudication, 2007. And that was, you were discharged on April 15th of 2008, and you made it a little over about a year and a half before you started picking up charges as an adult. Between your 2009 conviction, actually you had two of them, and they were 1 month apart. So you were sentenced on 9/16/2009, and you were back in front of the court, in front of a court within 31 days. Then in that second case, then 1 month later, in November of 2009, while you were on bond for one of the previous ones, you picked up a conviction. And looks like you hadn't paid all your fines and costs in that case, and there was an active warrant for you out of Manistee. Well, when that case was done in August 10th of 2010, you were back in front of a court within 2 months. While some of these are, I'm sorry, that was for a crime of dishonesty. You got a domestic violence on that time. But anyways, on this retail fraud in 2010, the crime of dishonesty that I just mentioned, you were back in trouble with the law. Oh, wait, but by the way, for entry 4 of 15, this one that I'm talking about, the retail fraud, you had 1, 2, no, why? That's 1 bond violation, failure to appear. And then you had 1, 2, 3, 4 different probation violations. In fact, when you were sentenced on April 6th of 2011, you were back in trouble in 2 weeks. Then between entry 5 and 6 of 15, you did have a gap of 2 years, and that's where we saw the morphine come in. And then probation was revoked in that file because you were violating probation quite quickly. Then, after being off of probation for 4 months, you picked up number 7 of 15. While it's just a driving license suspended, I tend to take those and say, well, this is a sign that a person will do what they want as long as they think they were not going to get caught. Well, you made it about a year, picked up a retail fraud, and 8 of 15. Then you, for 9 of 15, you were back in trouble about a year later. Then, while that case was pending, you picked up another charge in Benzie County, and this was a set of felony charges. You had multiple probation violations there. Number 11 of 15, you violated bond again and picked up an aggravated assault. Number 12 of 15, this is where you picked up other charges while violating probation. In fact, you violated probation for use of meth. You did have about a 3-year gap until you picked up another set of charges, and that was just a jostling. But your probation was terminated unsuccessful on that jostling case. Why? Because 3 months into that probation, you picked up a home invasion, which was apparently pled down to a domestic violence. So you got repetitive acts of violence in your history. Looks like you made it about a year, a little over a year before you picked up this case. And as we know, on it, you violated bond and picked up new charges. So definitely established a pattern to support the court with reasonable grounds. Now, it's not so much about, as I mentioned earlier, not about me as a judge, but when the court allows somebody to go to rehab, it does so because it cares and wants to give rehab. But I also do it to see how people behave. and whether or not they're going to continue their previous patterns. So that's a problem. So what I see here is 20 years of the same types of, almost 20 years of the same kinds of problems: violating bond, violating probation, acts involving drugs, acts involving crimes of dishonesty, acts involving violence. And the point here is it's not whether or not I give you the grace or this court gives you the grace. It's not because you've had lots of opportunities over several years of grace and opportunities, probation, and so forth. Now up to you to decide if you are going to take advantage of those opportunities and the benefits given to you. Absolutely. All right. The sentence in this case court is as follows. One second. I want to look up something. Also in the past, I see on that morphine case, which also had a driver's license suspended, 270 days. That was the end sentence after 110 initially, but after the probation violations. And then for the fentanyl case in 2016, my predecessor gave you 120 days only. So now I'm starting to look and now I'm starting to look and say, when I look at your prior confinement periods, the question is has it been working? Well, in this case, the court assesses the standard $68 state minimum fee, $130 crime victims' right fund fee, a $300 court cost, a $500 fine, a $300 attorney fee. DNA was already available. There will not be any supervision. So there's no supervision fees. And the court sentences the defendant to a jail term at the top of the guidelines, which is 330 days with 35 days of credit. I do so because I've already covered all the reasonable grounds. Every opportunity or grace has been provided to you, and you've thwarted them over and over and over again. So no, it's all right. That's the sentence. There's nothing you're going to say that's going to make it better.
Just no treatment, but another to continue to stronghold my treatment.
Yeah, well, they have people who come to the jail. You're not going to be placed on probation. You're telling court, just as Mr. Nago said, you're at that level where next time you're looking at presumptive prison cells on felonies, at least for drug charges. And you've had the opportunities and you rejected them. And it's your issue, not mine. It has nothing to do with this court. That's the sentence of the court. Have I missed anything, Mr. Blazak?
Are you making it work release?
I don't believe so, Your Honor. Mr. Denon? Madam Clerk is going to bring out to you, ma'am, 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the copy of the document. This document tells you that you have the right to file an appeal in your case. Based upon the plea, any appeal must be done by filing an application for leave to appeal and not a claim of appeal by right. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. Any questions, Mr. Niegos?
No, Your Honor.
All right. Thank you all very much. Ms. Sims, I do want you to use your time effectively. I'm hoping that the words I choose, not that everybody pays attention to them, sink in. You're at that level now where there is nobody else. I'm sorry?
It just upsets me because it was for my dead dog's tramadol and getting county in.
No, hold on.
Yes.
You're not.
That's upsetting.
Just a second.
I didn't even have it in my possession. And because of my past history from 12 plus years ago. That's what's upsetting.
Yeah.
I'm losing my job. I'm gonna lose everything.
Because of what?
Because of my past history.
Yeah.
People change, Your Honor, and I have changed a past history. The fentanyl charge wasn't even a fentanyl charge. I got larceny in a building.
Okay.
This is for past history, and I had my dead dog's trampled. I don't even know how it's illegal for me to have a prescription of my dead dogs anyways. This whole thing makes no sense to me. I'm just in shock right now.
Okay. I understand that you're just in shock, but this is not just because of your past history. This is because your pattern, and because in your pattern, you continue to demonstrate. You continue to violate bond. You continue to violate
There's
all.
somebody a county year.
You're gonna let me talk. Okay, hold on.
I don't really, I mean, at this point in time, it don't matter anymore. It doesn't matter anymore. You made your decision and it
Yeah.
doesn't matter. You just ruined my life. I was starting to do good. I had a good job. I had a good support system behind me, and all that is gone now. So it was like, what was the point? What was the point of me trying to change? This is why people don't change, because when they do, things like this happen.
We're very calm today, which is something I'm working on. Every judge has to work on it, and that's okay. If you want to blame me, Ms. Sims, that is perfectly okay. It's directed in the wrong direction. No, no, stop.
You don't care, I know.
Okay.
Can we please go?
You may leave because I'm about to add 60 more days to your sentence. We're adjourned.
Wow. So, look, yeah, people do change, and perhaps she has put forth the effort, but there's a reason why she's back in front of that judge for yet another sentencing, for yet another problem, for yet another bump in the road of her life, and it's got nothing to do with the man sitting in that chair on the left of the screen. It really doesn't. It's on her. And, you know, if you've followed me long enough, like Barbara for the last 8 months, congrats, Barbara. Like I said in the chat, I'm amazed that you've been able to stand me for this long, so thank you. But if you follow me, you know I'm about accountability. You know, cowboy or cowgirl up. Just accept what you've done, deal with it, and be better. Because, you know, yeah, the world is difficult. Life is difficult. Things are difficult, and there's not a lot about the current society that makes it easy on us. I'll stipulate to all of that. That having been said, we are all in the same boat. So learn to cope, learn to deal, and, you know, forgive me for swearing, handle your shit. That's the bottom line as far as I'm concerned. All right, off my soapbox. So I'm going to keep an eye on Judge Elmore's court. There's actually not a whole ton that's intriguing to me at the moment, and that's sometimes the case with Fridays. It's a lot of landlord-tenant or just stuff that's really kind of petty. So I'm going to put us in the Wayback Machine for a little while. I'm going to go back to yesterday's proceedings in Louisiana. There's another hearing that is probably worth a look. At least I'm guessing that it is. So we're going to go back to yesterday and spend a little time in Louisiana. Barbara asked about Dungeon Court, perhaps in the final hour. But let's go here for now.
Committee on Parole is called to order. Today's date is December 11th, 2025. My name is Danny Barra, serving as your chairman today. My colleagues are Mr. Tillis to my left and Mr. Ledoux to my right. Ms. Ledoux to my right. Panel still here at headquarters in Baton Rouge. Our remote location is now Hunt Correctional Center. Would the staff at Hunt please introduce yourself for the record?
Jason Russ, Assistant Warden.
Ashley Bradley, Assistant Warden.
Joe Butler's Classification.
All right. And Mr. Ortega, would you introduce yourself by giving us your full name and DOC number for the record?
J. Mike Ortego, 446422.
All right. I'm going to give you a brief explanation of the process. I'm going to read some information into the record, ask you to verify it. We're going to give you a chance to speak and tell us what happened, what you did to get yourself in trouble, and why you think now's the time to be released. We asked the warden to give us some input. We're going to have input from supporters and opposition and the district attorney, and then we'll conduct a parole interview. So let's begin. Today we have for parole consideration Jake Ortego, DOC number 446422, who's a first felony offender who was convicted of second-degree murder, and on October 14th, 2001, was sentenced to life that was later commuted to 75 years in East Baton Rouge Parish. Your parole eligibility date was 12/8/25. Your good time date is 9/7/64. Your full term date is 12/7/75. Does that information sound correct to you, Mr. Ortego?
Yes, sir.
All right. All right, well, go ahead and tell us, what did you do to get yourself in this kind of trouble, and what have you done since that would make us consider releasing you early?
First, I'd like to say good morning to the board and everyone. Last time at the clemency hearing, I had difficulty communicating my thoughts with the board. So if you don't mind, I took notes this time. I'd like to read from them, if that's okay. It's fine. All right. On the evening of June 26th, my brother and I, along with some friends, were at our condo drinking alcohol in celebration of my recent enlistment to the Navy, with the fulfillment of a lifelong dream of military service. Throughout the evening, we consumed multiple cases of beer in a form of competitive drink. While on a beer run, my brother received a page from a friend who informed him of a fight taking place at Highland Road Park. We all discussed the idea of going to watch, with me being the deciding factor since I wanted to go see it. We all agreed afterwards, we just go ahead and go to a club, and that's how we spend the rest of the night. Arriving at the park, we stopped on one of the side streets bordering the parking area. There, we waited watching a group inside the area. After some time passed with nothing happening, we made the collective decision, minus Doug, who was sleeping, to go in and check out what was going on. We woke Doug up, telling him we were going in. He jumped up, and he and David ran into the parking area, with the rest of us following. All right, so the guys already there briefly went on the defensive, but upon realizing we weren't the ones they'd been waiting on, the mood shifted. I began speaking with some and explained my commitment to the military and that I wanted them, Chad and Joey, to come visit before I left. While we were speaking, a fight broke out between Doug and Andrew, and I immediately ran over, pulling Doug away when someone struck me from behind. I reacted by turning and fighting the first person I saw, Lance Adele, whom I did not know before this night, and not until afterwards that it was him that I was fighting. After this, I went from encounter to encounter fighting, even breaking up a fight between Troy and David, my brother and one of my co-defendants. Alan then started his car and began driving toward us, forcing a group of us to jump out of the way. Made a couple of circles around the lot before his vehicle stalled. Once this happened, me, Doug, and David surrounded him and began beating him through the driver and passenger side window. Leaving this encounter, we surrounded Lance as he was on the ground in a seated position. I squatted down in front of him and began kicking him in the face and in the eye. Soon after this, cars began leaving and we made our way to ours. Reaching the vehicles, we noticed the tires had been slashed, and as things settled down, I realized I lost my shoe. While everyone was focused on the tires, I went back into the parking area to retrieve my shoes. After finding them and while putting them on, I noticed some of the other guys were there. A brief exchange ensued, and soon after, Doug and David showed up and I yelled, "Kill them." Chad, Joey, and Lance began running, with Lance soon falling to the ground. Catching up to Lance, we began kicking him, with me on his side, David the other, and Doug kicking his head. Not long after, Troy started calling for us to leave. In the early morning hours of June 27th, officers arrived at the condo, placed my brother and I in handcuffs, and brought us to the substation. This is when we were notified Lance Adele was killed. The gravity of someone being killed as a result of my actions weighed heavily upon me, forever altering my core sense of being. I did not want to be the kind of person who could take a life. Choosing to not address my disputes with violent behavior allowed me to move forward in my life while incarcerated in ways such as learning the automotive trade, which led to my becoming one of the first reentry vocational mentors, a program created to offer trade skills to inmates in our alternative sentencing program designed to assist in countering recidivism. While doing this, I was able to receive multiple ASC certifications. Then moving on from this to help in the creation of a machine shop located at the Angola Ranch House, a shop that was able to assist Angola's workforce as well as other institutions' maintenance departments. This opportunity led to a certification in metalwork, which was utilized in the renovation of the prison's historic Red Hat cell block. Accomplishing all this while still lacking the necessary life skills to manage socially, I continued using substances as a coping mechanism. After years down the path of substance abuse, I finally reached a point where I had to ask for help. Attending a recovery ministry helped me discover the things about myself which led me to act out or use substances to cope. Breaking free of addiction with the support and guidance of security and inmate pastors and inmate mentors, I began to mature in my thinking, behavior, and emotions. I learned to consider life's challenges as an opportunity to grow rather than turn my frustrations into crises in order to excuse and justify an inability to cope without the use of substances. Throughout this process, I attended classes like Celebrate Recovery, which gave me real-world approaches at applying biblical principles in my daily life and thinking for a change, which helped me to become more conscious of my thoughts rather than be controlled by them. Thus, it needed me to take more responsibility for the decisions I make. Now, in taking accountability, I desire to be responsible for more positive outcomes and apply myself in ways to achieve this, not just in my life, but in the lives of others. In ways such as taking part in the New Men Addiction Recovery Program in Angola, which segregates addicts from regular population as an intensive in-house rehabilitative effort combined with the sober living unit to help reacclimate addicts to a sober lifestyle. In each, I fill the role of peer support minister and sponsor, facilitating and co-facilitating classes. Also, after moving on from Angola to Hunt, recognizing another need where addicts were struggling, myself and a group of like-minded men came together in the creation of the Sober Living Unit, a program very similar to that of New Men. I'm now 6 years sober and act as extended support to programs such as those. I still seek to help men overcome their addictions while steering them towards positive alternatives, be they programs, sober living facilities, religious functions, or just positive encouragement in the many challenges in the day-to-day function of prison life. My driving force is a desire to lead men to a better life, not the taking of their own or another's by any involvement in destructive activities resulting from destructive thinking. Either in prison or not, I will continue a lifestyle that is in contrast to who I was when I took Nancy Dale's life. If this board votes for my release, I will immediately head to Colorado Springs, Colorado. My interstate compact was approved, and I will be living with my mother's sister, Nancy Pickett, and working for Nancy's daughter, Kristen Pickett, Nell, who is the owner of K9 Cuts LLC in Colorado Springs. Their support, as well as that of other family members located in Colorado Springs, combined with professional therapy, will assist in my continuing a life of recovery and becoming a contributing member of their community. I would like to thank you for the opportunity to speak and offer to Lance, his family, this board, and the people of Baton Rouge my deepest apology. There is no excuse for the trail of destruction left behind as a result of my actions. The impact of my reckless disregard for Lance and the resulting damage will forever be the driving force of my life, which is to now have a lasting positive influence on all those I encounter. I hope this is expressed in a life now committed to the restoration of other broken lives. Thank you.
All right. Warden, can you add anything to his behavior, his record, or anything like that?
As far as his behavior, Jacob's been here since November of 2022. His last DB report, disciplinary report, was on 9/20/2018. So he hasn't had any disciplinary reports here at Hunt since being housed here. He does have a low title risk score. He has completed some self-help programs and some educational programs. He's also completed both phases of the pre-release program. He is a minimum level trustee here at Hunt.
Gordon, has he completed a DOC approved substance abuse treatment program?
No, ma'am, that's not reflected at what I'm looking at.
Okay, thank you. I appreciate that information.
All right. Thank you, Warren.
Welcome.
Today we have people in support, and I'm gonna start with your mother, Diane Jarrow.
Yes, my name is Diane Jarrow. I'm here today to express my unwavering support for my son, Jake Ortego, as he seeks a second chance through parole. During his incarceration, he has demonstrated remarkable growth and dedication to personal development. He has taken responsibility for his past actions and is actively engaged in programs that have helped him reflect on his past mistakes, and I believe he is ready to re-enter society as a responsible and contributing member. As Jake's mother, I have witnessed his transformation, and I am confident in his ability to reintegrate into society. He is eager for a fresh start and is determined to make the most of this opportunity and a sincere desire to build a positive future. He has achieved various certifications in vocational programs such as metalworking, electrical, in order to find stable employment if granted parole. I believe beyond a doubt that given the opportunity of parole, Jake will become a contributing member of society. I will provide him with the means of transportation and monthly financial assistance as he makes this transition. We have agreed that he will follow any guidelines put forth by his aunt and his parole officer. If Jake is granted, he has already applied and been accepted at Alcott's and would leave Louisiana immediately with my sister Nancy Pickett to live with her. She will act as his mentor in helping Jake get established and ready to live on his own. I am committed to supporting him in his journey. My sister and her family, Jake's aunt and cousins, will be providing a stable and loving environment that will enable him to thrive. I believe that with a chance to rebuild his life, Jake will become a positive contributor to his community. I humbly request that you consider Jake's application for parole. I am confident that he will make the most of his second chance if granted. Thank you for the consideration and giving Jake the opportunity to demonstrate his commitment to a crime-free and productive life.
Thank you. All right, we also have an aunt, Miss Nancy Pickett.
Sir, I would like to respectfully express my support for the parole consideration of Jake Ortego. I would also like to acknowledge the tragic loss that they have suffered. My name is Nancy Pickett. I'm here from Colorado. Colorado has agreed to let him serve his parole time there. I'm 70 years old and live alone, and I think it would be mutually advantageous. I'm willing to fully support him in his quest to become an accessible, functioning member of society. I've already been to the courthouse in Colorado and have found numerous resources available to both of us. Should we have any questions or need guidance? Since we would leave the state, I think it would be easier to make a fresh start and smoother transition. I do know there will be some difficulty for all of us. Over the course of his incarceration, I've witnessed significant and genuine change in Jake. He has taken responsibility for his actions and demonstrated sincere remorse for the harm he has caused. Jake has also shown a consistent commitment to self-improvement by participating in many programs and earning numerous certificates. I think this shows his desire to live differently and contribute positively. If parole is granted, Jake will have a strong support system. I am prepared to assist him, and he will also have the support of family and numerous friends. Together, we will ensure his stability and provide structure and ongoing encouragement as he rebuilds his life. I fully understand the seriousness of the board's responsibility and do not take this recommendation lightly. I offer my support because I genuinely believe that Jake has earned and he deserves the opportunity to demonstrate the positive changes he has made. Thank you.
Thank you. All right, we also have in support Allison Edgar, but she is not speaking. And we also have in support Jennifer Cameron, who will be speaking. So let's hear from Ms. Cameron.
Good morning. Thank you for the opportunity to speak on behalf of my friend and client, Jake Ortego. Jake endured a violent childhood. He watched his father beat up his mother and brother, later beating Jake as well. Jake, small for his age, began fighting when people were bullying him in middle school. He turned to the rage he had seen his father use, fighting to establish a name for himself. After Jake began having further issues at school, his mother issued an ultimatum: enter the Navy like he had been dreaming of and get his life right, or leave. 3 weeks after turning 18, Jake was set to ship out. He, his brother, and his friends, highly intoxicated after splitting 3.5 to 4 cases of beer among 4 people by way of funneling 2 of them at once, were celebrating and heard about a fight happening at Highland Road Park. Jake and I grew up in the same neighborhood, and while it may seem odd, there was a lot of fighting going on in the area back then. I never understood why, but it was not abnormal for us to get a call to go watch a fight. It was also not abnormal for people from the neighborhood to participate in those fights. Jake has done a good job of conveying to this board what he remembers and what he's been told about that night, so I won't go through it again. But what I would like to emphasize is that Jake and his group had no plans to participate in that fight. They were there to watch. An absolute travesty occurred when one of the members of the group that did show to fight died that night. Recalling the details of that night is a struggle for Jake. And if you review the court records and statements of others, Jake has now sat before this board twice, taking full responsibility for everything that happened, even things that were not attributed to him by others. What this shows is that Jake knows that without the decisions he made that night, we would not be here. It's a maturity not often seen with offenders. When Jake learned Elle had died, he knew he needed to change who he was. Lance's death had a huge impact on many people, and Jake would never be the same. As Jake thought about what happened and listened to the information presented at trial, he realized he did not want to be the person they were talking about. He did not want to be a violent person like his dad. He has since worked diligently to change himself. Research has shown that the part of the brain that controls rational decision-making is not fully developed in young men until the age of about 26. Jake was far younger and made decisions based on impulse rather than reason. He spent his time since that night learning to control his anger and address the underlying issues that caused the immediate violent reaction when he got hit. He began taking classes immediately to learn how to do better and be better. Jake notes thinking for a change taught him to control those reactions to things, and Celebrate Recovery helped him identify what he needed to do to control his drug problem, which began in earnest after Lance died. Jake has had to cope with the fact that he took a life, and as much as he was working to be a better person, the weight of Lance's death affected him so profoundly that he began taking drugs to escape the pain. He had been dabbling in drugs before his incarceration, but while incarcerated, he was introduced to heroin and meth. He suffered with this addiction until 2018, when he realized he was surrounding himself with people who were keeping him exposed to drugs. He voluntarily approached a warden at Angola and asked to be moved to a different dorm. That move, along with the information that Jake learned through AA and Celebrate Recovery, allowed Jake to finally take charge of his own life. He lives the tenets of AA and Celebrate Recovery every day. He works hard to maintain his sobriety and plans to continue to do so. While incarcerated, Jake has been serving his community. As he told y'all, he was one of the first reentry mentors at Angola. He also helped establish the machine shop that has saved the state thousands, if not hundreds of thousands of dollars. Jake holds multiple professional certificates. He also helped to create the New Men program at Angola before he was moved to Hunt, where he created a similar program. He still serves as a sponsor and program. Jake's disciplinary record demonstrates his issues with drugs, but since he's been sober, he has had no further write-ups. During the last hearing for Jake's clemency, it was stated that neither Jake nor his family had apologized to the Adele family. While that's not allowed under Louisiana law, Jake did participate in the victim offender dialogue at their request. He did what he could to answer the family's questions honestly and completely. Unfortunately, we understand that the Adele family chose not to meet him at the end of that program. The process of the victim offender dialogue is long and forces offenders to face what they've done in a way that other DOC programs do not. Depending on the questions from the victim's family, the process forces offenders to relive one of the most intense, traumatic times of their lives. I have seen members who participated in the program, including Jake, stress so much that they began losing weight and suffering anxiety. I am so proud of him for getting through that process without using drugs again. If Jake can get through that process without relapsing, he can get through anything. Jake's reentry plan includes moving to Colorado, where he will live with his aunt and work with his cousin. I've confirmed that the IPOX has been approved, and Jake plans to seek individual counseling to continue his sobriety and deal with the issues he may encounter as he re-enters society after being incarcerated for 25 years. We ask this board to recognize that Jake has done everything he can while incarcerated and rehabilitate himself. He does not pose a threat to public safety, and it will not serve anyone for him to remain incarcerated. We humbly ask the board to grant Jake mercy and give him a chance to re-enter society under whatever provisions you see fit. Thank you.
Thank you. That would conclude our people here to talk in support. We have several people to speak in opposition, and I will let y'all choose who wants to go. You would be Miss Terry Mathern?
Yes, sir.
This is Miss Terry Mathern, the victim's aunt.
Thank you for allowing me to come today and speak on behalf of Lance. We are his only voice now because he has none. My name is Terry Mathern. I am Lance's aunt and godmother, and pretty much raised him half of his only 6 years of his life. I know you are all familiar with the case, but I am too. I have relived it. I have gone over it for 26 years. I learned what happened. So I hope you have studied the case as much as what I have. The why it happened, we'll never know. But what went wrong was Jake Ortega. Jake Ortega made the decisions he made that night. Not Lance Audell, that was there to watch a fight, not participate. Because Lance Audell had never been in a fight in his life before. He was there with some new friends, which Jake knows, Joey Casamini. So I guess Lance was caught in the middle between two groups of friends, and he was alone. As I say, two groups of young adults got into a fight that night. Whenever it tried to break up, and the group that Lance was with left. But Lance was the only one left behind. And Jake proceeded to fight just Lance, because he was the only one left there. As Lance fell, as trying to get away, Jake continued to kick him on the ground in his head. Witnesses also said that Jake jumped on his head. Lance was there left on the ground. Jake and them attempted to leave, but they realized their tires were cut on their vehicle. They couldn't go anywhere. At this point, Lance, stumbling, trying to get up, trying to run away from Jake. Jake chased him down willingly,
and continued to beat on him until a girl that was with Jake's group pleaded with him to stop because he did not believe Lance was breathing anymore. So what did they do? They retreated to the woods and hid. And as Jake said, he realized he forgot his shoes. That was so important. He forgot his shoes. So he went back to the park where this took place. Did he look on the ground and see the body that he had beaten and left for dead? No. Did he call for help? No. Did he have any second thoughts? No. Jake left back and proceeded to hide. So as Jake said, that night whenever the fight that he supposedly wasn't gonna fight, but yet he verbally said out loud to kill them. And it looks like that's what he did. But Lance was the object of that act, not by his choice, by Jake's choice. Only Jake made that choice because it was only Jake that fought with Lance, with no one around at that point. Lance was just a bright, kind, and loving kid. He was a kid. He hadn't even got his driver's license. He didn't get to go to prom. He didn't graduate from school. He didn't get to live out his life because of Jake's choice. Jake took his life. He took a part of our lives. He broke us. He broke our family in so many ways that we will not recover. I hope you can see that because that's how we feel. The pain is as raw today as it was that night when I got that phone call at 12:15 in the morning and said they had killed our Lance. Not knowing possibly what could have happened, an accident, kids get in fights, accidentally he could have fell, he could have hit his head. No, it was nothing so minor as that. It was a brutal attack. And he says, after he realized Lance was dead, he wanted to change his life, Well, let me tell you what happened after that. Every court appearance we made, Jake walked in there with his chest all bowed and done this. He was proud of what he had accomplished because he wanted people to know just how tough he was. There was even an incident at the courthouse when we so happened to get into the elevator, and who was in the elevator? But Jake and his mother. And he looked at us and he said, "Do y'all really want to get in here?" And we just looked at him. "Yeah, we're going the same place." Do you want to happen to you what happened to him? That was Jake's words that day. I vividly remember that. And it was 2 years before we went to trial. And then 2 years later, let's see, he had remorse. He wanted to change his life. He did the same thing then. 2 years throughout that trial that we had to listen to what Jake did. He had that same tough, bowed up look like, "Come and get me." That was Jake 2 years later. There was no remorse then. There's no remorse now after 26 years. And let's see, right, he did go through the victim's thing. My daughter attempted to do it, but we did not cancel it. They canceled it, the program canceled it because we were having this hearing that same year and it was within weeks of the time. The Idell family did not cancel because trust me, we would have loved to see Jake face to face and see what he had to say then. So as I go, it's 25 years. 25 years. Considered the value of Lance's life that he did not have compared to Jake's, the murderer? I don't believe. And I don't believe 18 years of him being on drugs, let's see, to cope with it? No, to have fun. Wasn't to cope with it, because he was coping with it just fine right after the murder. He had no problems. So I do not believe 25 years is enough for the value of Lance's life that he never had a chance at living. And this was not done to Jake. Jake done this to himself, his own choice, his own choice. And the choice was, he did it by his own hand. You tell me what person sits there, even after the fight has broke up and the guy is on the ground, already almost dead. And do you want to know what he done to him? Because I went and spoke with the coroner afterwards. What was the result of what Jake did? If you want to know just how bad it was, he actually said his brains were trying to come out from his nose, his ears, and his mouth. Does that tell you the rage that this person had? And you're gonna tell me what was in that young man's mind, body, thoughts is not still buried down in there? Because I believe if he had the chance and he was met with somebody that he thought, I'm gonna get the better of him, he would try. That's what I think, because he won't even look at me.
Please address us, please.
So I don't see any more remorse there today. All these meetings, he's so apologetic. Not one tear has ever fell from his eyes, not one. So I beg of you to understand the feelings that we have went through. And I do not feel that this 25 years is enough for Jake Ortego to know that I can go out and live my life now. And I'm not gonna have a problem at all. And I beg of you, for this young kid, that was a wonderful, wonderful kid.
How old was Lance at the time?
Lance was 16 and a half. As I said, he hadn't even got his driver's license. So it was not his choice to drive up and meet this fight. He was riding it, and I said to this day, it was his mistake, because supposedly the new friend that he had met and had a car, who doesn't want to go with their friends when they got a car? But coincidentally, he was also a friend with Jake's. Lance was the only one there that was not known by any of the people there. So I think that's why he was attacked, because no one knew him. So I beg of you, please consider what Lance went through to what Jake is going through. I don't think there's a comparison. So I beg of you, please, not this time, at least not this time. Give us more time. Thank you.
Thank you. All right, we'll hear from.
I don't know if she's still on there.
Which Pickett's not here?
Is Brandy,
She was on, but it's been so long, do you know if she's still on?
Okay, who we want next?
There she is.
All right, Brandy? Brandy Hughes?
Yeah.
All right.
Unmute your microphone.
Okay, I think I have it fixed now.
All right, thank you.
First, thank you for listening to us today. My name is Brandy Hughes. I strongly oppose the parole of Jake Ortega. I would like to express how strong my opposition is to the possibility of the release of this individual. The brutal murder of Lance Odell had a significant and lasting impact on my life. And I feel it is important that the parole board understands the concerns that I continue to carry. Although time has passed, I still experience emotional, psychological, and practical related to this case. These effects influence my daily life, my sense of safety, and my overall well-being. Based on my experiences throughout this process, I do not believe that release at this time would be appropriate or would provide me or my family with the reassurance and security that we need to move forward. I asked the board to consider the ongoing impact of Jake's crimes, what they have had on our life, and the serious concerns I have about the potential risks associated with his early release. I appreciate the opportunity to share my perspective and trust the board will weigh it carefully. I'm going to leave you with the last words that Lance said. He lay there on the ground, bleeding to death, internally bleeding in the brain. The last words as he laid on that ground was, "Mama, Mama, Mama." Thank you.
All right, I think we understand what she's trying to tell us. Can we hear from Mr. Mathern?
Won't be short. Laws the law, he was given life no parole. Then he got committed to life with parole. Understand that? Only by his own admission. He said, I've only been sober 6 years. His first 18, 19 years in there, he did what he wanted to do. So I'm not convinced that he's completely recovered. I think he's found a good spot then. If he's helping the other people and helping himself, I think he needs to stay there a little bit longer and continue this program. I do not think he's ready to come out. Thank you.
Thank you very much, Mr. And we have Ms. Tracy Barber with the DA's office.
Good morning. Thank you, Tracy Barbera, for the 19th Judicial District Attorney's Office. Let me first let you know that Mama that Brandy just referred to emotionally could not be here today. I stood in this room with other family members 2 years ago for the clemency hearing for Jake ago, and Lisa could barely stand up from this building. There are health concerns going on right now, but I assure you that everything she said to the board 2 years ago, she would be saying to you, and the grief you've seen from the family members is a daily struggle for them, and were she emotionally able to be here today, she too would be with you to please not the facts and circumstances I have been very accurate described to you, and I know that you have been a pre-parole investigation. I was the trial attorney in this case, and I assure you that the emotions and the trauma that went on in Judge Richard Anderson's courtroom throughout this proceedings was difficult for all involved. Yes, we were dealing with very young people who made very bad decisions that night at the park. Ms. Cameron speaks of all the studies that have been across the world about the development of the brain and the difference between the 16, 17, 18-year-old brain and 26-year-old brain. I just reiterated that Jake Ortega continued to commit crimes, violate the law. We have a 26-year-old brain in the Department of Corrections. I do not know why the substance abuse continued. If it was to help him deal with the fact that he was incarcerated or to help him deal with the fact he had killed a 16-year-old boy. Maybe it was a combination of both. But the bottom line is that it did occur. And I heard his family members say he wanted to be given the opportunity, or they wanted him to have the opportunity to live a productive life crime-free. I submit to you that he has been living a productive life in the Department of Corrections. I have the respect for these programs that the department has set up and the programs that Jake Ortego is participating in. Unfortunately, he did continue to use substances. I don't know the exact circumstances of how he obtained them, but I dare say because he was placed in positions of trust that enabled him to potentially get his hands on those substances. But he has lived a productive life, not the productive life that maybe Lance would have given an opportunity to live, or that others in this room have lived, but he has done good things in the Department of Corrections. As by his own admission, he has been 6 years sober. And I submit to you that, yes, we are here today to talk about remorse and responsibility, but there needs to be accountability. And I do not think that the 25 years he's been in there have truly been 25 years of accountability. The last 6 years have been years of true accountability because he has remained sober. He has refrained from disciplinary write-ups. Ms. Cameron said if he were able to get through the victim dialogue without relapse, he can get through anything. So I respectfully submit today, let's see if he can get through parole tomorrow without relapse. So then we'll see you again at some point in the future. Thank you.
Thank you. All right. Besides the district attorney office being opposed, we have opposition from the sheriff's office. Rural letter stating opposed due to violent offense. We have opposition from the chief of police, not served enough time, and we have opposition from the attorney general's office. Your case has been assigned to Ms. Ledoux, and she's going to ask you a couple of questions before the vote.
Actually, Mr. Barra, based on all of the testimony today and my thorough review of the case, I don't have any questions of Mr. Ortego. Thank you for the packet by his attorney. I gleaned a lot of information. The Department of Correction does have basic for parole. You have not met the substance abuse programming requirement. You have done some very good things though. So I'm going to turn my time over to my colleagues if they have questions.
Mr. Tillis, you got any questions?
Mr. Jake, you said your growing up was kind of rough. Father?
Sir?
You said when you were growing up, your father was kind of rough with you?
It was more so with my mother and my brother. He was very violent. He was a drug addict, and kind of a raging drug addict, and he was very destructive.
What kind of work did your dad do?
Sir?
What kind of work did your dad do?
All right. The only job that I'm aware he ever had, past 8 years old, I didn't have much to do with him. But his mother owned a trailer lot, and he just was a maintenance man, kind of moving trailers around, took care of the lot. As far as I know, that's all he's ever done.
So you didn't spend much time with him?
No, sir.
And I have no more questions.
Mr. Barra.
Go ahead.
This is Assistant Warden Russ. Researching Jake's master prison record, I did find during his annual assessment in 2023, he did complete substance abuse treatment and anger management here at home.
Okay.
Which program was that?
It's just showing substance abuse treatment. It didn't give me a name. It's just saying completed both.
This is Assistant Warden Buttress. That we offer a residential drug abuse treatment program here. It's, and I believe what you're referring to is possibly the Steve Hall program, more of a long-term substance abuse program. This is a more abbreviated program that we offer here at Hunt. It's an in-house program where you live in the dorm for a period of time and you do graduate from that. It is recognized as a certified treatment and rehabilitation program, but it is a more abbreviated substance abuse treatment from what I believe you're referring to, like a Steve Paul.
Thank you. I'm prepared to vote. My vote today is to deny parole based on lack of institutional progress and the opposition from victim and law enforcement.
Mr. Tillis.
I concur with Ms. Ledoux.
And I'm going to concur also, vote to deny, but do commend you on the work you've done there for the past 6 years and encourage you to keep on doing a good job like you are doing now and show us how you handle this one. So today, this means that your parole has been denied, and this would conclude our business, Mr. Artigo, at 11:16.
So again, we were in the Wayback Machine for this one. This was from yesterday. This was the hearing that immediately followed the hour-long one that we watched yesterday, that we watched live. And it kind of went about the same way, didn't it? The board let people talk forever, like they were interested in what they had to say, and then the actual pronouncement of their findings lasted about 10 seconds. This board is weird. I mean, we enjoy watching them. It's educational and entertaining for sure, but they're so unpredictable in what they'll do and how they behave. You know, you get them one day and they're just urging people to shut up and cut it short. But yesterday they were just letting them run on forever. But they didn't want to say anything. Just bam, here's our decision. Have a nice day. Really crazy. So I still have eyes on Washtenaw County with former U of M coach Sharon Moore. There was just a news report that they've finally filed the charges so they can arraign him. They don't know what those charges are yet. They haven't made it public. It is possible that he shows up for his first appearance before we leave in about 35 minutes. If he doesn't, if it's streamed, we'll cover it. But in the meantime, because it's been a couple of weeks, let's go to that wonderful place in southern Ohio where people come out of the woodwork to go to this dark, dank basement with a grumpy judge and blood red carpet and World War II Soviet-era lighting, and the souls of the dead echoing just about as loudly and as frightening as the voice coming through Judge's microphone. Ladies and gentlemen, I give you Dungeon Court. Enjoy.
You engage in a pattern of conduct knowingly that caused Courtney Beater to have mental distress to themselves or a household member, that you would cause physical harm to Courtney Beater or a member of her family or household. The charge is menacing by stalking. It's a first-degree misdemeanor. Maximum penalty 6 months in jail with $1,000 fine. Do you understand this charge?
Yes, sir.
Do you understand the rights defendants have in criminal cases?
Yes, sir.
Do you have any questions for you in our plea?
Yes, sir.
What plea do you enter?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
Well, it's seasonal. Wintertime, no. I run landscaping, so I would need one appointed.
What's your, I have to determine your gross annual income. Do you know do you file an income tax return?
No, I haven't. I just started at summertime, so I haven't done anything really yet. So basically, I'm not working. Let's just say that. I have no income.
Do you have any money saved?
Yeah, a little.
Okay, tell me about that.
I just save money at home when I do little side jobs.
Well, tell me how much you got.
$400 or $500.
And you have no income?
No, sir.
showing he also has a warrant. I don't know, do you have that, CRB 21-583?
I do not.
They said that when I had court on the 4th in Lawrence County, they dropped that. That was a domestic violence through my sister, and she dropped that.
Okay. We're gonna pull that file, so we'll recall you. I don't have it in front of me, so just have a seat, we'll call, I don't have to pick this, we'll recall it.
Okay.
State of Ohio versus Brian Martin, case number TRC 25-30-15, A, B, and C.
Are we allowed to go?
So are you Brian Keith Martin?
Yes, sir.
All right, Mr. Martin, your case number is 25-30-15, and the state is alleging that you committed an operating a vehicle under the influence charge on December the 6th of this year at 12:53 a.m. in Perry Township. The state's alleging that you were operating a vehicle under the influence of either alcohol, drugs, or a combination of those things, and that this would be your first conviction.
Yes.
On our first offense, the maximum you face is 6 months in jail, $1,075 fine, and 3-year license suspension. The minimum you face is 3 days in a treatment program, $375 fine, and a 6-month license suspension. The state's alleging that you submitted to a urine test. The urine tests go to a lab in Columbus for testing, and it takes a while. I don't have any results now as to what the state's going to allege was in your urine. Eventually, we will get those back, but it takes quite a while to get the results back. The other charges that you face, failure to control your vehicle, that's a minor misdemeanor, maximum penalty is $150 fine. And driving an unsafe vehicle, also a minor misdemeanor, maximum penalty is $150 fine. So you've got 3 charges. Do you understand the 3 charges?
Yes, sir.
Do you understand the rights you have as a defendant?
Yes, sir.
How do you plead to these charges?
Not guilty.
You want a lawyer appointed to represent you?
Yes, sir.
Are you working?
Yes, sir.
What do you do?
Auto collision.
Auto collision, is what you said? Are you paid by the hour in your job?
Yes.
How much per hour?
I think it rounds up to like $16 an hour.
How many hours a week do you work?
40.
Do you have any dependents?
My son and my ex, yeah.
Okay, and you're supporting your son by some sort of means?
Huh?
You're paying child support or doing something to support your son?
Yes, we don't do child support, but I pay for my son, yes.
All right, you're eligible. I'll appoint Mr. Smith to represent you. Not guilty plea is entered. There's a urine screen here, so we're gonna have to go out a ways before that's gonna be back.
Judge, I'm here the 23rd or 26th of January, maybe we can see if it's back.
Well, that's probably gonna be longer.
I can go further.
How about February?
Until February.
February 6th?
Let's see. That's a Friday, yes, sir. I can do
February
it.
6th, okay. I'm gonna set the next hearing for February 6th. 26th. And that'll be a pretrial at 10 a.m. Mr. Martin can sign a $1,500 signature bond. So what this means, Mr. Martin, you're just signing a piece of paper that says, I promise I'll come to court when I'm ordered to. And if I don't do it, I'm going to pay $1,500 as a penalty. Plus you get a warrant for your arrest for not showing up. So that's the worst part. But if you come to court, you don't have to post any money.
We need to be fingerprinted.
You will need to be fingerprinted, so it's a fairly new thing. So, Mr. Cooper's gonna bring you a piece of paper, you gotta take it to the jail and turn it into them, and they will fingerprint you and let you go. You don't have to stay there, but you gotta get your fingerprint.
Call you before this?
Yeah, call me, ask me for saying there's my information, ask for something. He's my legal assistant, get you to talk about the case for the 6th. Just have a seat in the lobby, they'll get you a card, you gotta get fingerprints. Just have a seat in the
if that finishes the arraignments we have, I think we got more in the works. They bring some in the mornings and they got to process the paperwork. It's not done yet, so we'll get, you were told to be here, and I know there are some that are being recalled. Don't leave, you stay, and we'll get to you as the paperwork's brought out. We're going to start some of the pre-trials that are set for today, so we need the lawyers and their clients that have pre-trials on the docket to be in the courtroom now.
State of Ohio versus James Garrett Adams, case number CRA 25732, CRB 25138, CRB 24130.
One of these is an arraignment, it looks like.
Yes, sir.
All right, this is Mr. Nash's case, and it looks like there's a new charge. I don't know if you're aware of that.
Today I found out.
Bailiff just gave you a copy of it. Do you want me to read that in the record? Or
No, Judge.
you waive that?
We do.
John?
So how does that, how do we want to proceed then, now that we've got a new charge?
I've spoke with the prosecutor. Mr. Adams is in the process of cleaning up his property. It's not fully complete, but he needs to finish it. We're asking if we can reset that on January the 23rd. And if there's a time waiver that's needed, he'll do it. And we'll do it orally here in court as well.
Well, part of our effort to kill more trees, Mr. Heald always has a written waiver.
That's true.
That he wants signed. That came after a Court of Appeals decision that
We'll do one.
didn't like some of our oral stuff. So, Mr.
We killed a
Heald.
lot of trees doing this. too,
Yes,
by the way.
they have to pay the price. What's your position? He wants a continuance to January 23rd, I believe you said?
Correct, Your Honor. We're not opposed to that, Your Honor. And we just provided some new discovery to Mr. Nash today in the proceeding with the case that was here previously. So we want to give him an opportunity to review that stuff too.
All right, so we're going to, because there's several things pending, and I'm going to continue all of them. Some are pre-trials. This new one's going to be a preliminary hearing. January 23rd next year for preliminary hearings and pre-trials at 10 o'clock. Looks like there is a bond up on the some of the previous things. So since he's appeared today, I'll allow him to sign an OR bond.
Thank you, Judge.
On the new charge of $2,500. I think he's going to have to go under this new policy that we have. You'll have to go get fingerprinted again, I believe.
Oh, okay.
On every case they want.
Sheriff's Office?
Yes.
Okay.
So Mr. Cooper will give him a form to take to the sheriff. Then we'll be coming back on the 23rd of January for all hearings.
Okay.
In this matter.
Did they get the paper to
January 23rd, 10 o'clock.
Thank you, Judge. I'll have Mr. Adams wait out in the lobby for the paperwork.
Yes.
Okay, thank you.
Thank you.
What date?
State of Ohio versus Aristides Alexandropoulos, case number PRC 25-27-24.
Okay, Mr. Haslam is here in person, so is the attorney.
Yes. Your Honor, the state and defendant have reached an agreement in this case in exchange for dismissal of all the charges except for the OVI. The OVI will be amended to a first offense, regular test OVI. Mr. Alexandropoulos will plead guilty to that and complete the 3-day dip course. The firearm that was taken from him during the stop will be returned to him.
Mr. Hill.
Your Honor, with respect to the gun, he has a job which requires him to, I guess, carry money and things of that nature, and that's the reason he has the firearm. We got the urine result back for the alcohol, and it tested 0.213. So it was not a high score, but it was above the minimum per se. And so we're okay with, if the court is, of course, with the return of the weapon. I told Mr. Haslam that he needs probably to do an entry on that unless.
Is that the sheriff's office or OSP? Do you know?
OSP, Your Honor.
If you would, please prepare an entry that'll direct them to return it to, he is the owner.
Yes, Your Honor.
So he'll need to get a certified copy from the clerk and then take it to the post to get it returned to him.
Yes, Your Honor.
And so we are okay with the also dismissal of the marked lanes and the safety belt upon the plea to the OVI, and our request is for the mandatory minimums on the OVI.
Okay. All right, sir, you have a right to make a statement if you want to. You're not required to. Do you have anything you want to say?
No, sir.
And Mr. Hassel, anything you wish to say?
No, Your Honor.
Okay, so 25 CRA 690 is dismissed, as are 20 TRC 25, 2744 B and C. There's a plea of guilty to the A case. Is that correct?
Correct, Your Honor, to the OVI.
So we'll do sentencing on that. I'll impose a $375 fine where the cost be paid. License suspension will be 6 months, and that starts today. There was not an automatic license suspension in this case. 30 hours of community service, 2 years of level 4 probation. Jail is suspended. He's to attend and complete the driver intervention program. The firearm that was taken by OSP is to be returned to defendant. There will be a separate entry specifically directed to that, and you'll need to put in some description if you have that, or if you don't, there probably is, I haven't looked, probably some description in the file as to the weapon involved. There'll be a description of it. His review hearing then will be July 6th of next year at 9 a.m.
Your Honor, the only question I would have is with respect to the 6-month license suspension, because he does drive for work, and we have the dual problem, as the court is aware, of Mr. Alexandropoulos being a West Virginia resident. West Virginia is obviously going to take extreme steps with respect to the license. We would ask that he be permitted to at least drive for work, and the West Virginia issue with the license suspension is going to be a quagmire and a nightmare to resolve anyway. So if there's any way we could work on the license suspension here.
Yeah, he can have, he can actually have unlimited driving privileges as far as I'm concerned, but he has to then put the blow-and-go device on his vehicle.
And he plans to do that, Your Honor.
Okay, so just talk to Mr. Major when he meets with him. The closest facility that supplies that is out of Portsmouth, so he can make the arrangements there, have a place, and then get unlimited driving privileges. And we'll need an order from the court granting that. And we've never had a problem in West Virginia, but in Kentucky, we have had some courts that said, we don't care what the court in Ohio says about that. That's pretty rare, but just be advised that it's going to show up on your driver's license as if somebody checks the computer that you're suspended, then you're going to have this piece of paper from me saying, oh yeah, he can drive if he's got this device. The other thing, if you don't want to place the device, I can give you limited driving for work, some other things, but not unlimited. So you got to prove then if you get stopped, I'm out doing what I'm supposed to be doing in the time frame I'm supposed to be doing.
And Your Honor, he's already received the interlock letter from the West Virginia DMV. Okay. So I'm not sure what the court's preference is if he completes the interlock through West Virginia and provides proof to the court.
Okay. They'll require, from my experience too, I'm ordering him to do the 3-day school. They'll accept that, but they will require him to go to some kind of program themselves independently, but they do accept the Ohio. I'm requiring, I have to require it in Ohio for a first offense, so he'll need it for both states, really.
Yes, sir.
You need to get that done, and Mr. Major can help you. You don't have to go, there is one here in Lawrence County, you don't have to go to this one. You can go to it if you want to. It's more expensive than some of the others. I know the one in Chillicothe is like $200 less, so if it's worth to drive to Chillicothe for $200, but anyone that's approved by the state of Ohio, you can go to. If you go to the one here, I know they'll file paperwork with the court to show that you've been there. If you go to one in Cleveland, I don't know what they'll do. So
Yeah.
it's a different state. It's the state of Cuyahoga. So, any questions, sir?
No, sir.
You'll need to see the probation officer, then you're free to go after that. And his review hearing is July 6th of next year. It gives you a lot of time to get it done. You should get it done. If you have, you don't have to show up. If you don't get it done, you need to show up and explain why and ask for more time. If you blow it off, that's where you can go to jail. Blow it off and don't show up, and we have plenty of people do that, then they get a warrant. So just take care of it, and don't ever have to go to jail.
Yes, sir.
See Mr. Major, you're free to go.
July 6th, but I'll give you all that. Wait, just out front.
Good to see you, Mr. Haslam. Don't be a stranger. You've been a stranger for quite a while.
Your Honor, that's Mr. Smith's fault.
Okay.
Probably is. State of Ohio versus Jacob Lee Lindsay. Case number 25-788, A, B, and C. Jacob Lindsay.
This is case number 25-788, A, B, and C. Jacob Lee Lindsay. Jacob Lee Lindsay here. I don't have any proof of service on file. It's a summons, but it doesn't say it's been served. So at this point, I'm going to pass it for service.
State of Ohio versus Hayden Curry on a recall, case number GRC 25-2004 A and B, and case number CRB 25-789.
All right, so this is a recall on Mr. Curry. Mr. Curry, I have another charge on you now. It's criminal damaging is the charge. The bail's bringing you a copy of it. And the basis of this charge is, it's the same date as the OBI event, but it states alleging in this charge that on December 7th, 2025, you knowingly caused or created a substantial risk to property at the Sims Creek boat ramp, and that you didn't have the right to do that. So that's criminal damaging. Second degree misdemeanor, maximum penalty is 90 days in jail, $750 fine. Do you understand the charge?
Yes, sir.
And you had told me before you understood your rights. Now, I didn't know this charge was coming, and you didn't either when you entered your plea to the other charges. So if you want to withdraw them, and it was uncounseled, you didn't have a lawyer. If you want to withdraw your guilty plea, I'll allow you to. How do you want to proceed, sir?
I'll just plead guilty, sir.
Okay, so you want to plead guilty to the previous charges, which were no driver's license and operating a vehicle intoxicated, and now you got a charge of criminal damage. And as I understand, you want to plead guilty to that also?
Yes, sir.
Okay. I'll accept your guilty plea, and there's an affidavit signed by Deputy Cochran with regard to this charge of criminal damage. So I'm going to read that into the record, and then if you want to make a statement or explanation about that, you can. Deputy Cochran says, on December 7th, I was dispatched to the boat ramp at Sims Creek for reports about reckless operation of a motor vehicle. Calls were originating around 12:05 a.m. I made a trip out there. There was no contact made with any individuals at the boat ramp, but there was damage could be observed to the grass and embankments around the boat ramps in Chesapeake. caller stated that they observed 2 vehicles doing donuts in the grassy area of the boat ramp and operating their vehicles in a reckless fashion. However, when I got there was no one there. Then on the same day at 1:41 a.m., there was a second call placed into dispatch that was similar to the previous one, saying there was reckless operation of motor vehicles located in the same boat docks area. And this was a different caller, stating that they were 2 SUV type vehicles doing donuts in the grass located around the boat ramps. And then there was a third call from Tracy, the person I guess identified themselves as Tracy Henson, who lived near the boat ramp. Deputies responded again. There was debris in the area from spinning tires. Deputies traveled a little further out Township Road 123 and located a vehicle that had lost control leaving Township Road 123, struck a mailbox, went on the opposite side of the road and off the road towards Sims Creek. I'm familiar with Township Road 23 through prior calls and knew that the road travels a little further out into the dead-end neighborhood. I was able to locate 2 Jeep Cherokees in the driveway with fresh dirt and mud all over the bodies of the vehicles. While I was pulling up, I observed one male standing in the driveway looking at a Jeep. As I was driving closer, I was able to see a second male in a black t-shirt running away from the driveway through an open garage door and an open breezeway exiting the house in the back. I called the first male to me, and he identified himself as Anthony Bailey of Huntington, West Virginia. During my contact with Anthony Bailey, he advised that he was the driver of the 2004 Jeep Grand Cherokee. They were in fact doing donuts in the boat ramp area. And he advised that when they left the area, was traveling on Township Road 23, lost control of his Jeep, going off the edge of the road, struck a mailbox, and slid over the embankment. He called his friend Hayden Curry, who was just in front of him a short distance. Curry returned to the crash site and used a ratchet strap to pull the Grand Cherokee out and freed up both vehicles. Asked him if he had been drinking any tonight because I was able to throw red glassy eyes and could smell odor of alcohol coming from the person. He admitted to have been drinking prior to the accident, prior to doing the property damage at the boat ramp. I advised the homeowner that I need to speak with the other driver of the white Jeep who had taken off on foot and believed he was still on the property. And he went and retrieved Hayden Curry from the house to come speak with me after discussing what was found at the boat. I was with him, talking to him about his vehicle, asking about the property damage. He admitted to going down there and doing donuts, causing property damage as well. When I was speaking to Hayden, I noticed an odor of alcohol coming from his person. Lawrence County Sheriff's Department turned the crash over to the State Highway Patrol for investigation and potential OVI charges. Okay, that's pretty much it. Okay, anything you wish to say, Mr. Curry?
Just ask you to have some mercy on me, Judge. I made a stupid mistake. It won't happen again.
Okay. Tell me about what, you said you worked, what do you do?
I laid blacktop for asphalt contractors in Lavalette, West Virginia.
And did somebody haul you to work, or how do you get back and forth to work when you don't have a driver?
My girlfriend drives me to work.
Okay. Is she here today?
Yes, sir.
Okay, where is she? Okay. All right, well, this is a stupid young male, let's say. You get a few of those. Sometimes, you know, stuff comes, you get away with a lot of stuff, and sometimes it comes back to bite you. This is one that bit you pretty good. So, I think some community service and, Mr. Cooper, you need to get out there and scope out the boat ramp and see how bad this is. You know.
Your Honor, I've got pictures somewhere.
Oh, okay, good. Let's see the pictures.
Looks like it's grass turned to mud.
Yeah, it looks like a plowed field now. So I'd say some community service out there. I don't know when we can get it done, because it's probably might be frozen now, but you need to get out there and rake that out, maybe plant some grass seed and put some straw down.
Yes, sir.
Get it looking like it should. You know, a lot of people go there and hang out and fish and different things, and it's just, I'll agree with your characterization of stupid. Stupid young male stuff. So, how old are you, girlfriend? 19, okay. That's part of what young males need, is a female telling them what to do. Because I don't really see, I've been doing this over 30 years. I can't think of one time where I've seen a female out doing donuts.
Your Honor, she did tell me.
Okay. So if you listen to what she tells you, you'll be a lot better off.
Yes, sir.
So you have the right to tell him, don't do this stupid stuff. If he doesn't do it, then, you know, he doesn't pay attention to you, that's his fault, and you can take appropriate action. Okay, anything else you want to tell him?
No, sir.
Okay, on the criminal damaging, I'm going to impose a $200 fine where you pay the court costs. There'll just be one court cost when it's all happening. One court cost for everything. Let's do 20 days in jail, but I'm going to suspend all of it. Okay. So you don't have to go to jail as long as you do the other stuff I'm going to tell you to do. I want you to do 5 days of community service. I want him on Sunday's community service out there cleaning up the mess he made with the boat dock. Mr. Cooper's in charge of community service. You'll work with him. So, what's your work schedule?
I'm laid off for the winter, sir, so.
Okay, so you can get out here anytime.
Right
now,
after
are you
this.
living in Chesapeake now?
Yes, sir.
Okay, so transportation's no issue. You're close by.
I can walk there, sir.
Yeah, okay, that's the right answer. I just was it Monday or last week where I had a guy that had community service? He was about your age, young, fit, able to, and he said, I can't get there because I don't have a ride. He lives in South Point. It's like 5 miles away.
Yeah.
That's not, it doesn't matter where you live. If you got community service, you got to get there and do it, or go to jail, because once you go to jail, you can sit on your cot all day. You don't have to worry about any transportation. It's all provided for you. So getting to do community service is a privilege. It's in lieu of, instead of going to jail. And it does, you know, it doesn't cost the county much. You go to jail, we got to feed you. You don't want to eat jail food. You don't want to sleep there. So just take care of this, do your community service, and do anything else that I order you to do, and you won't have to see the inside of the jail.
Yes, sir. Oh, she's still here.
I'll set a review hearing for you July 6th of this coming year. So you got half a year to get all this done. You're going to have more stuff to do on your OBI. If you can't afford to pay the fines, I'll let you work it off. You get extra credit for every extra day of community service you do. You get $50 credit toward your fines. Okay. Then on the OBI, I'll give you the minimum fine. I know you don't have a lot of money, so the minimum I'm allowed to give you is $375, so that's bad enough. Your fine's $375. No court costs because I'm putting it on the other case. On this one, I thought I saw it on the, okay. One court cost, she says she's putting it on the OBI. You don't have a license, but I'm going to suspend you from getting a license for 6 months. So you won't be able to get a license for 6 months. Another 20 days in jail, and I'll suspend all of this on the conditions you do the other stuff that I'm ordering you to do. Another 5 days of community service. So you got, because I always do that on OBI, but you got the donut stuff you got to pay for too. So you got 10 days of community service total between the two cases. 2 years of probation. Your probation will end once you do everything, so you shouldn't go 2 years. You do have to go to what on your judgment entry it says DEC, that stands for Driver Intervention Program. Ohio requires it, so because you don't have a license. Whenever you go to get a license, either it's West Virginia or Ohio, they require this 3-day program. So you got to go do that. Mr. Major will explain to you what you got to do to get signed up for that and complete it. And that's an inpatient program. So what's that mean? You got to go in and stay for 3 days and get talked to about the dangers of driving under the influence of different substances. So that's required. Or I got to make you do, under Ohio law, the legislature says, I got to make you go to jail or go to the program. You'd rather go to the program than go to jail.
Yes, sir.
Same review hearing date, July 6th to 26th. You got a no operator's license. I'll give you a $50 fine on that. Get your driver's license. You can't exist. You can't live around. It's not New York City. If you're in New York City, maybe you don't need a driver's license. You take the subway. If you live in Wayne or Chesapeake, which are pretty much the same thing, you need a driver's license because you got to get around. She should not have to haul you around everywhere you need to go. Or your parents. I don't know how you've been getting around for the last 4 years, but get a driver's license. You're not going to be able to for a while, but eventually you will. Get it done.
Yes, sir.
No excuses. Then, is that it? I guess that's it. Okay. That's all your cases.
All right, thank you, Judge.
Okay. Mr. Curry, do you have any questions?
No, sir.
You gotta go see the probation officer. His office to the left, as you go out of the courtroom, 90-degree left, west.
Okay, guys, we're going to interrupt this. This is, from the looks of it, the arraignment of University of Michigan former football head coach Sharon Moore. So let's sit in on that. To be clear, the lack of audio at the moment is on the court's end, not on this end. So we'll hang tight and see if they get the audio rolling. But it's got nothing to do with us.
Your Honor, we are asking for a $25,000 cash for surety bond in light of the fact that we cannot ask for you to deny bond. I get that he is a man of means, and so this is a bit of a nominal monetary ask, but quite frankly, it would be an ask that I would make for any defendant charged with these offenses before you. So what strikes me as perhaps more important in this scenario are conditions that I would like to ask for, because of course, as you know, Your Honor, you're tasked with trying to make sure that he reappears, but also the safety of the public and this victim in particular. So, Judge, in addition to an ask for a $25,000 cash or surety, we are asking, should he post that? Should you impose that? We are asking that you order that he undergo a mental health evaluation. We are asking that you order him to submit to a GPS tether further that he be ordered to surrender his passport. Judge, the reason, Your Honor, the reason we make those requests is in light of the factual scenario that gives rise to these charges. My best understanding from a thorough review of the police report and as much body-worn camera as I've had an opportunity to review is that I understand that our victim broke up. They had an intimate relationship for a number of years, defendant and victim. That our victim broke up with this defendant on Monday morning early. That there continued to be defendant making numerous phone calls and sending numerous texts from that time moving forward that she did not answer, did not respond to, did not want. That eventually she presented herself to the University of Michigan, cooperated in some form of investigation there. As we all now know, defendant was at some point on Wednesday afternoon fired from his employment. He then, at some point soon thereafter, came to her apartment in the address that is alleged in the complaint, barged his way into that apartment, immediately then proceeded to a kitchen drawer, grabbed several butter knives and a pair of kitchen scissors, and began to threaten his own life. I'm going to kill myself. I'm going to make you watch. My blood is on your hands. You ruined my life. And a series of very, very threatening, intimidating, terrifying, quite frankly, statements and behaviors there in that apartment. It was only then, Your Honor, when the victim, she called her attorney and then at some point indicated she was going to call the police, and then he left. And so, Your Honor, while I understand that there isn't evidence to suggest that he directly threatened the victim with any of those implements that I've indicated, the totality of the behavior is highly threatening and highly intimidating. She was terrorized, Your Honor. And in light of the totality of all of those circumstances, we consider the defendant to be a risk to public safety, a risk to this victim. And it is for those reasons that we are asking for those specific conditions. I'm more than happy to answer any other questions that the court may have or give you further information. I appreciate the opportunity. Thank you.
Assignment is the bottom.
Your Honor, let me start at the end where the people ended. In terms of risk to public safety, my client's 39 years old with zero prior criminal history, zero prior contact with the criminal justice system in any fashion. The threat to public safety argument by these charges, maybe that's the point, but there's no evidence to suggest that he's a threat to public safety. The next thing is that the people referenced the court rule that I want to come back to, that you can't deny bond in a situation like this, and they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly the police report, and they reviewed thoroughly the body cam. I've had none of that opportunity. And that's too early for that in the proceedings, so when people come here and make factual representations, although I trust Ms. Mirsky very much as an officer of the court, I have no ability to respond to those factual representations. So here's what I'm going to ask the court. The monetary bond component, the two considerations by court rule are my client will appear. Let me speak to that. He's got a home here. His family is here. He's got ties to our community. He's retained a local counsel. Second thing is that my client is not otherwise a danger to the public or danger to the complainant. There are other, that is why monetary components are requested, but there are other measures to address them. For example, the request for a GPS tether, that was an expected request. My client would gladly comply with that request. The second thing is my client having no contact. Certainly, we have no objection to that order, and my client would be at his own peril if he were to violate that. So there are both. In terms of surrendering the transport of passport, Your Honor, there's no really indication that he is like this. My client has those established ties that I talked about. But in addition to that, Your Honor, he would have an order from the court like everyone else does. There would be no leaving the state, let alone the country, without permission of the court, and he would certainly abide by that. Your Honor, with respect to the request for a mental health evaluation, I will represent a few things that are my understanding. again, without being privileged to have reviewed discovery that. My understanding is that following his arrest, my client was taken to the St. Joseph Mercy Health System for an evaluation, a mental health evaluation. My understanding is following that evaluation, he was not turned over for a commitment, but instead turned back over to law enforcement for lodging. That's where he's been, the Washington County Jail said. I can also tell the court that the Community Mental Health Department saw my client yesterday for an evaluation as well, without any further recommendation. If you make that a condition of bond, I can tell the court that he get a mental health evaluation, he will absolutely comply and follow any aftercare recommendation. Lastly, Your Honor, with respect to the bond amount. I forgot to explain about weapons. He has no weapons, but he'll surrender. If you order that he surrender any weapons that he doesn't have, he'll be glad to comply with that condition. With respect to the bond amount, Your Honor, in a case like this, with charges like this, in a normal circumstance, we'd be requesting the personal recognizance bond and frankly expecting the court to order. We all know this is not our ordinary circumstance. It's not an insignificant amount of money to anyone. And I ask that the court set the bond amount to the principles not of my client's bank account, but to the principles of the charges and to the principles of the courtroom. Therefore, I'm requesting that if the court orders a monetary component at all, that it be with the $25,000 10% privilege. And also, Your Honor, if my client is to order to a GPS tether, things have to happen pretty significantly to try to get that in place in time for what we'd like to use.
Mr. Moore, could you state your name, please?
Jerome Moore.
Sir, you are not to use alcohol, marijuana, or any other controlled substance that is not prescribed to you. You are not to possess or purchase a firearm or any other dangerous weapon. You are not to engage in criminal conduct of any kind whatsoever. You may not leave the state of Michigan without permission of the court. Prior to your release, you will be placed on a GPS tether. You will not be released before that GPS tether is placed upon you. You must continue all mental health treatment as a condition of your bond. The named victim in this case will not be placed on the record. You may not have contact with that individual. That means no calling, no writing, no video chatting, no texting, no emailing, or any other form of contact the human mind can possibly fathom. No one in the world thinks that this person is going to reach out to you. Should they do so, and again, no one thinks that they're going to, you may not reply in any form or fashion. The named victim's address will not be placed on the record. You may not go to that location for any reason whatsoever. Are we understood on the no contact and no go to, sir?
Yes, Your Honor.
If you have any questions about that, you have a good attorney, simply ask them. You understand?
Yes, Your Honor.
Bond will be set in the amount of $25,000 cash surety, as requested by the prosecution's office. The court does not determine innocence or guilt. This court determines flight risk and community safety. The court finds with these conditions in place, it has been met. Mr. Simon, we are setting probable cause conference at this time for January 8th due to the holidays and scheduling. Is that a good court date for you?
Your Honor, my client will waive his right to have that next court date. We'll discuss it. Also, try to coordinate calendars with Ms. Mears. In support of that, I think we'll both be able to do a second vote for that. And I'll add in the community records. I understand that there is a continued investigation. So in addition to discovery, I don't have
So it will be January 26th, 2020. January 22nd. January 22nd, 2026, 9 a.m., 14A1 District Court, Courtroom C. That will be in person. Sir, do not violate these bond conditions. Follow all orders of the court. Stay in contact with your lawyer. That concludes this hearing.
Thank you very much.
So 14A1 District Court, that's Simpson. So we might actually be able to see where this goes from here. So that will be cool, because 14A1 is Simpson. So, and we know he streams, although not everything. Some things he holds back. Just to be clear, since it wasn't mentioned, at least not audibly, because they had some audio difficulties, I did my best to clean it up there for us. And what did they finally set? January 22nd. Thank you, Michael. So, Ashley, please make a note of that if you would, please. But just real quick before we go for the day, what he was charged with, because it didn't come through, at least not audibly. 1 count of felony home invasion. Also misdemeanor stalking. 2 counts of misdemeanor breaking and entering, or entering without breaking. So that is what that is. All right. So that's what he's been charged with. We'll keep an eye on that. They got that in right in the wire. I was monitoring it. They kept queuing it up for like the last half hour, and then like right at the line where I'd normally call it a day, they popped in, so I thought I'd show it. All right, guys, we will be back live Monday, 10 a.m. Eastern, 7 a.m. Pacific. There will be best of again this weekend. We did that last week. Reception was good. We're going to do that again. And that is Saturday morning, Sunday morning, 10 a.m. Eastern, 7 a.m. Pacific, so be sure to check those out. And, of course, we'll post our videos and shorts and everything else throughout the weekend, as we are apt to do here at the TCF Bunker. All right, guys, enjoy your weekend. Take care of yourselves. Look forward to seeing you live again on Monday and through the best ofs over the weekend. Take care. God bless.